ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸುತ್ತಿರುವ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರ ಮುಖ್ಯ ಪರೀಕ್ಷೆ ಅಂತರ್ಜಾಲ ತರಬೇತಿ ಶಿಬಿರದ 6ನೇ ದಿನದ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಮಗೆಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಇಂದಿನ ಉಪನ್ಯಾಸಕರಾಗಿ ಶ್ರೀ ಜಗದೀಶ್ ಮಂಡರಗಿ, ಹಿರಿಯ ವಕೀಲರು, ಬೆಂಗಳೂರು ಇವರು ಆಗಮಿಸಿದ್ದಾರೆ. ಇವರಿಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ ಹಾಗೂ ಲಾ ಅಕಾಡೆಮಿ ಮೂಲಕ ಪರವಾಗಿ ಸ್ವಾಗತವನ್ನ ಬಯಸ್ತಾ ಇದ್ದೇನೆ. ಇಂದಿನ ವಿಷಯ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್. ತಮಗೆಲ್ಲರಿಗೂ ಕೂಡ ಮುಂದಿನ ಪರೀಕ್ಷೆಗೆ ಶುಭ ಕೋರುತ್ತಾ ಶ್ರೀ ಜಗದೀಶ್ ಮಂಡರಗಿ ಅವರಿಗೆ ಉಪನ್ಯಾಸ ಮಾಡಲು ಕೋರುತ್ತಿದ್ದೇನೆ.
Yes, sir. Thank you, sir. I sincerely thank the Bar Council and its all members. Our senior advocate Koteshwara is always there, and Basraj is taking lots of pain, especially to improve the standard of our profession. I'm really very happy with regard to that. He is doing the continuing education effort with full effort, which is helping all the advocates, not only the young advocates. And the Bar Council is doing this continuing education since a long time, continuously, throughout state. And I am the beneficiary in that, because I have not only gained friendship with so many advocates throughout the state, but also, more importantly, I came to know about CPC little bit after getting the opportunity from the colleges, Renakacharya College, Vivekananda Law College, and Keli Law College, and Lahari, and especially the Bar Council of Karnataka. Then only I realized, so I don't know the code of civil procedure. Now, I also wish all the examinees, advocates who are taking the examination for DJ, final exception, all the best. And it is your mind which plays a very vital role. Always we have to remember, all of us have got that experience, including our Basuraj and Koteshwara, all the members. To achieve anything in our life, our mind plays a very vital role. Unless we have got a control over mind, it is very difficult to achieve anything. And the nature of the mind, as we all know, that very, very funny, very treacherous. It always try to control us. Mind try to control us. So that is why it is said, mind is best slave, but the worst master. For that, just I will give one example of Mata Amrutandamai, and we will come back to the topic. She always gives one story. I have told ಈ ಕಥೆಯನ್ನು ಹೇಳಿದ್ದೀನಿ, ಅವ್ರು ಹೇಳಿದ್ದನ್ನ ಕೆಲವು ನಿಮ್ಮೆಲ್ಲರಿಗೂ ಗೊತ್ತಿದೆ, ಸುಮಾರು ಜನಕ್ಕೆ. ಒಬ್ಬ ರಾಜ ಇದ್ನಂತೆ, ವೆರಿ ಗುಡ್ ಕಿಂಗ್. ಸೊ when everything is fine, mind will not allow us to enjoy that. That is the nature of the mind, fluctuating. So he was bald. King was bald. ಬೋಡುತ್ತಲೆ ಅವನ ಪಾಪ. ಅವನು ಅಷ್ಟೆಲ್ಲ ಇದ್ರೂ ಸಹ ಅವನಿಗೆ ಒಂದೇ ಯೋಚನೆ ಏನಪ್ಪ, ನನಗೆ ಕೂದ್ಲಿಲ್ವಲ್ಲ ಅಂತ. ಇಸ್ ಎ ಗ್ರೇಟ್ ಕಿಂಗ್. ಹಿ ವಾಸ್ ವರಿಂಗ್ ಅಬೌಟ್ ದಟ್. ಯಾವಾಗಲೂ ಮನುಷ್ಯನ ಮನಸ್ಸು ಅದನ್ನೇ ಯೋಚನೆ ಮಾಡುತ್ತೆ, ಏನಿಲ್ವೋ ಅದ್ರ ಬಗ್ಗೆ ನೀವು ಯೋಚನೆ ಮಾಡೋದು. ಹಾಗೇನೆ ನಾವು ಮನಸ್ಸಿಗೆ ಏನ್ ಮಾಡು ಅಂತ ಹೇಳ್ತೀವಿ ಅದನ್ನ ಮಾಡಲ್ಲ. ನೀನ್ ಮಾಡುವಂತೆ ನಾನು ಮಾಡಲ್ಲ. ಕಾಫಿ ಕುಡಿಬೇಡ, ಇಲ್ಲ ಕುಡಿದೇ ಕುಡ್ತೀನಿ, ಏನಾಗುತ್ತೆ. ಇಟ್ ಇಸ್ ದಿ ನೇಚರ್ ಆಫ್ ಮೈಂಡ್. ಸೊ ಹಿ ಸ್ಟಾರ್ಟೆಡ್ ವರಿಂಗ್ ಅಬೌಟ್ ಹಿಸ್ ಬಾಲ್ಡ್ ಹೆಡ್, ಅಂಡ್ ಹಿ ಕಾಲ್ಡ್ ದಿ ಫಿಸಿಷಿಯನ್. ಪಂಡಿತರನ್ನ ಕರೆಸ್ದ, ನೋಡಿ, ಐ ವಾಂಟ್ ದಿ ಹೇರ್ಸ್ ಆನ್ ಮೈ ಹೆಡ್. ನೀವೇನಾದ್ರೂ ಮಾಡಿ. ಇಲ್ಲ ಸ್ವಾಮಿ, ಆಗೋದಿಲ್ಲ. ಬಟ್ ಹಿ ವಾಸ್ ನೋಯಿಂಗ್ ದಟ್ ಇಂಪಾಸಿಬಲ್. ನಿನ್ಗೆ ಗೊತ್ತಲ್ಲ, ನೀವು ಇದನ್ನ ಏನಾದ್ರು ಮಾಡದೇ ಇದ್ರೆ ಶಿಕ್ಷೆ. ಸರಿ, ಹಿ ಅಫ್ರೈಡಿಂಗ್ ದೇರ್ ಲೈಫ್. ಪಂಡಿತರು ಏನ್ ಮಾಡಿದ್ರು, 2-3 ದಿವಸ ಕಾಲಾವಕಾಶ ಇಡು, 1 ವಾರ ಅಂದ್ರು. ಆಯ್ತು. ಆದ್ಮೇಲೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಹಿ ಸೆಂಟ್ ವರ್ಡ್, ಕರ್ಸ್ರಿ ಅವ್ರನ್ನ, ಪಂಡಿತರನ್ನ. ಈಸ್ ದ ಕಿಂಗ್. ಬಂದ್ರು. ಏನಾಯ್ತು, ಕಂಡಿಡಿದ್ರ? ಹೌದು ಸ್ವಾಮಿ, ಕಂಡಿಡ್ದಿದ್ದೀನಿ. ಕೈಯಲ್ಲಿ ಒಂದು ಬಾಟ್ಲ್ ಇಟ್ಕೊಂಡಿದ್ವಿ. ಈ ತೈಲವನ್ನ ತಾವು ತಲೆಗೆ ಹಚ್ಕೋಬೇಕು. ಅಷ್ಟೇನಾ? ಖುಷಿ ಆಗೋತ್ತು ರಾಜುನಿಗೆ. he was so happy. he was already dreaming with full of hairs in his head. ತಲೆಯಲ್ಲಿ ಕೂದಲೆಲ್ಲ ಬಂತು ಅಂತ ಹೇಳಿ ಖುಷಿ ಅವನಿಗೆ. ಅದು ಇಮಿಡಿಯೇಟ್ ಆಗಿ he grabbed that. ಆಮೇಲೆ ಆ ಪಂಡಿತ ಸ್ವಾಮಿ ಒಂದೇ ಒಂದು ಸಣ್ಣ ವಿಷಯ ಇದೆ. ಏನಿದು? ಏನಿಲ್ಲ, ಅಂತ ದೊಡ್ಡದೇನಿಲ್ಲ. ಈ ಎಣ್ಣೆ ನೀವು ತಲೆ ಹಚ್ಕೊಳಕ್ಕೆ ಮೊದಲು ನೀವು ಹೆಗ್ಗಣಗಳನ್ನು ಯೋಚನೆ ಮಾಡಬಾರ್ದು. ಹೆಗ್ಗಣಗಳ ಬಗ್ಗೆ ಡೋಂಟ್ ಥಿಂಕ್ ಅಬೌಟ್ ರ್ಯಾಟ್ ವೆನ್ ಯು ಅಪ್ಲೈ ದಿ ಆಯಿಲ್ ಇನ್ ಯುವರ್ ಹೆಡ್. ಅಷ್ಟೇ ತಾನೆ ಒಡಿದ್ದೇರು. ಶುರು ಆಯ್ತು ನೋಡಿ. ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಹೋದ, ರೂಮ್ ನಲ್ಲಿ ಬಾಕ್ಲು ಹಾಕೊಂಡು ತೆಗಿತಾನೆ ಎಣ್ಣೆ. ಏನೋ ಪಂಡಿತರೇನು ಹೇಳಿದ್ರಲ್ಲ, ಮನಸ್ಸು ನೋಡಿ ಹೇಗೆ ಬಿಡೋಲ್ಲ ಅಂತ. ಹೆಗ್ಗಣಗಳನ್ನು ಯೋಚನೆ ಮಾಡಬಾರ್ದು. ಹೆಡ್ಗಳ ಬಗ್ಗೆ, ರ್ಯಾಟ್ ಬಗ್ಗೆ ಶುಡ್ ನಾಟ್ ಥಿಂಕ್. ಒಂದು ಬಂತು, ಎರಡು ಬಂದು ಹೆಗ್ಗಣಗಳು. ಯಾವಾಗ ಬೇಡ ಅನ್ನ ಇಟ್ ಸ್ಟಾರ್ಟೆಡ್ ಪೌರಿಂಗ್ ಇನ್ ಹಿಸ್ ಹೆಡ್ ಆಲ್ ದ rats. He was so fed up with that, he just threw the bottle and left. So that is the nature of mind. So we should always have awareness about our mind's attitude, and we always try to bring it on our aim and objects. So I also request all of the participants, I don't want anything. I want your mind only for this discussion session. Of course, naturally, you will be thinking of so many other things. Shortly, you are getting to attend the examination. ಹತ್ರ ಬಂತು, ಟೈಮ್ ಅದನ್ನ ಮಾಡಬೇಕು, ಇದನ್ನ ಮಾಡಬೇಕು. ಆಮೇಲೆ ಅಡ್ವೊಕೇಟ್ಸ್ಗೆ ಇನ್ನೇನು ಯೋಚನೆ, ಅಯ್ಯೋ ಇವತ್ತು ನಮ್ಮ ಆಫೀಸಿಗೆ ಕ್ಲೈಂಟ್ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ ಫೀಸ್ ಕೊಡಕ್ಕೆ ಇಲ್ಲಿ ಕಾಯ್ತಾ ಇರ್ಬೇಕು, ಎಷ್ಟೊತ್ತು ಕಾಯ್ದು ಎಷ್ಟೊತ್ತು ಮಾಡೋದು, ಇವೆಲ್ಲ ನಾಳೆ ಯಾವ ಕೇಸ್ ಬರುತ್ತೋ ಏನೋ, ಮನೆದು. All those problems will be there for every one of us. But that particular time, that's why another thing always Mata Amrutanmayi says is, live in the present. We should cultivate that. Not in the past. Our mind always try to rely upon the past incidents and the future incident. Try to bring it back and be in the present. So with these few words, I once again wish all the participants, those who are taking examination, best. And now coming to the topic, the Code of Civil Procedure. Wonderful enactment, very, very crucial enactment for the advocates who practices on civil side. And once you know the Code of Civil Procedure, we can conduct any suit effectively. And now and today, we are going to restrict only to the topics which are required for the purpose of taking your district judge examination. Only those important topics we will cover, because as we all know that it is very big enactment, the Code of Civil Procedure, sections and orders. Now, commencing from Order 1, which deals with regard to parties to the suit. Order 2, framing of suit. And then we will jump to Order 4, coupled with Section 26 and connected with Order 6, 7, 8. You see, whenever we are going to file a suit, most necessarily, we should know who has to file the suit, against whom the suit has to be filed. Recently, we were dealing with regard to a very interesting case where a suit was filed for specific performance of the contract by the purchaser against his vendor. Then the vendor was a lady. Her husband filed an application to implead under Order 1 Rule 10(2) of the Code of Civil Procedure, alleging that he is the owner of the suitable property. Wife is only a name lender. So therefore, he is a necessary and proper party, and he should be allowed to come on record. You may be knowing Supreme Court decision 2005. The Supreme Court has taken a view that In a suit for specific performance of contract, a third party cannot be permitted to come on record who claims adverse interest with that of the vendor. The case reported in 2005, part 6, SEC, page 733. So there, the Supreme Court has given the guidelines in a suit for specific performance of the contract, who can be arrayed as parties and who cannot be. In that, it has been very clearly mentioned by the Honorable Supreme Court, a third party against whom the claim is not there in the suit and who is not a party to the contract should not be permitted to come on record. ಅಂತಹವರನ್ನ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಪ್ರತಿವಾದಿಯಾಗಿ ಸೇರಿಸೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ, ಆರ್ಡರ್ 1 ರೂಲ್ 10 ಅಂತ ಹೇಳಿ ಆ ತೀರ್ಪಿನಲ್ಲಿ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಹೇಳಿದೆ. ಮೂರನೇ ವ್ಯಕ್ತಿ ಆಗಿರಬಾರ್ದು, ಅವನು ಅಡ್ವರ್ಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಕ್ಲೈಮ್ ಮಾಡಿರಬಾರ್ದು ಮಾಲೀಕನಿಂದ, ಮತ್ತೆ ಅವನ ವಿರುದ್ಧ ಯಾವುದು ಪರಿಹಾರ ಕೇಳಿರಬಾರ್ದು. ಅಂತಹ ಸಂದರ್ಭದಲ್ಲಿ he cannot be and he should not be a signatory. ಆ ಒಪ್ಪಂದದಲ್ಲಿ ಅವನ ಪಾರ್ಟಿ ಆಗಿರಬಾರ್ದು, ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ನಲ್ಲಿ. ಆವಾಗ ಅವನನ್ನ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಸೇರಿಸೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ದಿ ಕೋರ್ಟ್ rejected that application, accepting the verdict of the, relying on the decision of the Apex Court in 2005, part 6 of the Supreme Court, which I mentioned. But the contention of the purchaser was, no, earlier to the agreement of sale itself, I have issued a notice to the purchaser and my wife, in whose name I have purchased the property. ನನ್ನ ಹೆಂಡತಿಗೆ ಮತ್ತೆ ಅವನು ಕೊಂಡ್ಕೊಳ್ಳೋಕೆ ಹೊರಟಿದ್ನಲ್ಲ ಅವನಿಗೆ ನಾನು ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ನೋಡಪ್ಪ, ಇದು ದಿಸ್ ಇಸ್ ದಿ ಸಿಚುಯೇಷನ್, ಐ ಆಮ್ ದ ಓನರ್, ಶಿ ಇಸ್ ಓನ್ಲಿ ನೇಮ್ ಲೆಂಡರ್, I have paid all the money, nothing but benami. That's what we can come to conclusion. Therefore, don't continue with the agreement and proceed with that agreement of sale. ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದೀನಿ. In spite of that, he has filed a suit, but I have not been made a party purposefully. They have colluded together. Adding to that, the wife has been remained absent. She has been placed ex parte, which clearly goes to show that there is a collusion. In addition to that, he took up a contention. No, the decision relied on by the plaintiff is not applicable to the facts and circumstances of this case. ಈ ವ್ಯಾಜ್ಯಕ್ಕೆ ಇದು ಅನ್ವಯ ಆಗೋದಿಲ್ಲ. ಯಾಕೆ ಅಂದ್ರೆ I am not claiming adverse interest against the defendant vendor. ನಾನು ಅದನ್ನು ಕೇಳ್ತಾ ಇಲ್ಲ. Supreme Court has taken the view, Privy Council in fact has taken the view that a benamidar will be acting on behalf of the true owner, like an agent, like a trustee. So any decision rendered under such circumstances against the benamidar, in whose name the property has been purchased, it is binding on the true owner, and he can implead himself as parties, otherwise the decree is binding on him. So in view of that, in addition to that, the decision relied by the plaintiff counsel is hit by principles of per incurium. Is hit by principles of per incurium. What do you mean by per incurium? Per incurium ಅಂತ ಹೇಳಿದ್ರೆ Latin maxim. In a decision rendered by the apex court, a particular point is not raised and considered and given decision on that point. So in a subsequent case or in a different case, if the party raises such a point, and whenever that decision is relied on, he can say that this point which I have now raised was not considered by the apex court in that case. Therefore, that decision is not applicable to this case. That is known as per incurium. ಅಂದ್ರೆ ಈ ಅಂಶವನ್ನ ಆ ವ್ಯಾಜ್ಯದಲ್ಲಿ ತೀರ್ಪಿನಲ್ಲಿ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಅದನ್ನು ಯಾರು ಎತ್ತಿಲ್ಲ, ಆ ತಕರಾರನ್ನ, ಆ ಅಂಶವನ್ನ, ಮತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ ತೀರ್ಮಾನವನ್ನ ಕೊಟ್ಟಿಲ್ಲ. ಹಾಗಾಗಿ ಆ ತೀರ್ಪು ಈ ಕೇಸಿಗೆ ಅನ್ವಯ ಆಗಲ್ಲ. So this is the argument canvassed by the intervening applicant, impleading applicant. But the court has rejected that application, and the remedy, as we all know, that once the IA has been rejected, unlike earlier days before amendment of the Code of Civil Procedure by 1999 and 2002, where we used to file the CRP under section 115 on the ground that the court which passed the order has exceeded its jurisdiction or failed to exercise the jurisdiction, or it is not a speaking order. No application of mind. In addition to that, to prefer a revision, one of these grounds should be there under 115 to the High Court. Against such order, there should not be no appeal. These are the conditions earlier to the amendment to 115. Now, even all these things are there. It is not appealable. The order is not appealable either under Order 43 or under section 104 of the Code of Civil Procedure. And the order suffers from any one of the grounds: exceeded its jurisdiction, failed to exercise the jurisdiction, or no application of mind in passing this order. Even all these things are there. Amendment says if that order were to be made in favor of the person who is challenging that order, should have decided its case. Then only revision lies, not otherwise. So this was done, this amendment was made to 115 to see that litigant should not challenge the orders, interlocutory orders, by filing the revision before the Honorable High Court. But to little extent, they were successful. The amendment was succeeded in curtailing the people or litigant from challenging those orders by way of revision. But it has not stopped the litigants from challenging those orders, as we all know that now we are challenging those interlocutory orders by way of writ petition under Article 226 of the Constitution of India, which is more expensive than 115. So in very few cases, we can say the case will be decided by virtue of the interim orders, which were to be made in favor of the person who is challenging those orders. So like that, that order has been challenged before the Honorable High Court, and the case is pending before the Honorable High Court now. So who is the proper party and who is a necessary party? Those things we have to examine on the basis of the nature of the case. In a case for partition, we have to make all the persons who are entitled for a share, co-owners, co-parceners, all those people have to be made parties. Otherwise, if you do not make those persons as parties, even though Order 1 Rule 9 says petition suit should not fail for misjoinder of parties or non-joinder of parties. Order 1 Rule 9 says, but further it says, provided this is not applicable to the necessary parties. Order 1 Rule 9 is very clear. So, if a person is a necessary party, then the case can be dismissed. And order 1 further says the objections with regard to the non-joindering of necessary party should be raised at the earliest point of time. So, who is a necessary party? Who is a proper party? We are all familiar with that. A person without whose presence, if the court cannot pass judgment effectively, then he is a necessary party. He should be there. A co-partner who has got, co-owner has got a share in the suitable property, he should be made a party because he is a necessary party. He's got share in the property. On the other hand, if a person even is absent, if the court is able to pass the judgment effectively, then he is only a proper party. So if the plaintiff in confusion, whom I have to make party, shall I make him or not, if he is in doubt, then he can array any person without any prayer. Then he will be called as not only proper party, he can also be called as pro forma party. Pro forma party. Against whom no relief has been claimed. So that is how we have to deal with regard to the parties to the suit, necessary party, proper party, and unnecessary party, misjoinder of parties. If a person has been made one of the defendants who is no way connected with the case or cause of action, only the intention to harass, there is an unnecessary party. Then the suit can be termed as suit misjoinder of parties. So they can make an application. Similarly, when the defendant raises an objection that suit is bad for non-joinder of necessary party, one of the co-owner has not been made party, then the plaintiff should take steps by making an application order 1 Rule 10 and implead him immediately. Similarly, misjoinder of parties, they can make an application again under order 1 Rule 10. Delete our name. You are not necessary parties nor proper parties. So once the amendment is made, then the cause title has to be amended by the plaintiff, who is the author of the plaint. And one more important provision under order 1 Rule 8, as all we know, that representative suit. Where more persons are interested in the suit scheduled property or subject matter of the case, then with the leave of the court, the plaintiff can institute a representative suit, in which event the court will ask him to take a public notice by publication in the papers and calling all the people who are interested either to join or oppose or support the suit. Then it will proceed. Then framing of the suit. So to remind you, we are only discussing with regard to the topics which are important for your district judge examination, not other provisions. And in brief, because the time is also not much. So 2 becomes very, very relevant in framing the suit, where it says you can join different causes of action in one suit. It is for the court to permit or refuse to permit the plaintiff to join the different causes of action. ಅದಕ್ಕೆ ಬಿಟ್ಟಿದ್ದದು, ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಿಟ್ಟಿದ್ದು. ವಿವಿಧ ವ್ಯಾಜ್ಯ ಕಾರಣಗಳನ್ನ ಒಂದೇ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಸೇರಿಸೋದಕ್ಕೆ ಅದು ಸಮ್ಮತಿ ಕೊಡಬಹುದು, ಇಲ್ಲದಿದ್ರೆ ಕೊಡದೇ ಇರಬಹುದು. ನ್ಯಾಯಾಲಯ ಏನಾದ್ರು ಇಲ್ಲ ಪ್ರತಿವಾದಿಗೆ ತೊಂದರೆ ಆಗುತ್ತಪ್ಪ ಅಂತ ಹೇಳಿ ಕೊಡದೇ ಇರಬಹುದು permission. It can refuse to permit the plaintiff to join the different causes of action, in which event the plaintiff is required to file a separate suit. But most important thing in order 2 is relief. As we all know that the plaintiff is required to seek for the entire relief for which he is entitled to on that cause of action. ಆ ವ್ಯಾಜ್ಯ ಕಾರಣದ ಮೇಲೆ ಅವನಿಗೆ ಏನೆಲ್ಲ ಪರಿಹಾರ ಬರಬೇಕೋ ಎಲ್ಲ ಪರಿಹಾರವನ್ನು ಅವನು ಕೇಳಬೇಕು. ಕೇಳದೇ ಇದ್ರೆ Order 2 Rule 2 says that the relief for which he was entitled to the earlier suit, he is not entitled to file another suit. ಇನ್ನೊಂದು ವ್ಯಾಜ್ಯವನ್ನು ಹಾಕೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. That is what we call it Order 2. The second suit is hit by Order 2 Rule 2 ಅಂತೀವಲ್ಲ ಇದು. ಒಂದನೇ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಆ ವ್ಯಾಜ್ಯ ಕಾರಣದ ಮೇಲೆ ಅವನಿಗೆ ಏನೆಲ್ಲ ಪರಿಹಾರ ಬರಬೇಕಾಗಿತ್ತೋ ಎಲ್ಲವನ್ನೂ ಕೇಳಬೇಕು. 10 ಲಕ್ಷ ಕೊಡಬೇಕು ಡಿಫೆಂಡೆಂಟ್. He should seek for entire 10 lakhs. He cannot seek only for 8 lakhs. But Order 2 also further says he can seek the leave of the court to file a separate suit. ಅದು ಮಾಡಬಹುದು. ಅದಿದ್ರೆ he can file a separate suit. Otherwise, no. I always say, and we were also not knowing till recent time, only if the earlier suit is dismissed and the plaintiff files another suit, then we have to invoke Order 2 Rule 2. That was our view. Most of us were. But the Supreme Court, in a decision, has held even in the pending suits also. A suit was filed in that particular case. 3 suits were filed for injunction based on the for specific performance, but mere injunction suit was filed. Thereafterwards, in that suit itself, defendant appeared and said that no, he is not. All the agreements are created, forged, which shows that he is refusing to execute the sale deed, vendor. So thereafterwards, the plaintiff filed one more suit during the pendency of those suits itself for specific performance of the contract. In that second suit, the defendant took up a contention. No, the second suit is hit by Order 2 Rule 2. But the plaintiff said that suit is still pending. Under those circumstances, the Supreme Court held that no, even the earlier suit is pending. The principles of Order 2 rules are applicable. For that, you can look into 2013, Part 1, Supreme Court cases, page 625. 2013, Part 1, SCC, page 625. Virgo Industrial Engineering Private Limited versus Venture Tech Solutions Private Limited. So then the Supreme Court observed he can file an amendment application in those earlier suits which are pending, seeking for the relief of specific performance of the contract itself. Fortunately, the limitation was there. We can also examine the applicability of Section 17 of the Limitation Act. So that is how we have to deal with regard to the framing of suit. Then how to file a suit? What are the principles of pleadings? How the written statement has to be filed? All those things are covered under Order 4, Section 26, where it says suit has to be instituted by presenting the plaint. Both of them are amended. We are well aware of that. Plaint has to be filed in duplicate. ದ್ವಿಪ್ರತಿಯಲ್ಲಿ ಹಾಕಬೇಕು, ಜೊತೆಗೆ ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಅನ್ನು ಹಾಕಬೇಕು, ಶಪಥ ಪತ್ರ ಪ್ಲೀಡಿಂಗ್ಸ್ಗೆ. ಹಾಗಾಗಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಗೂ ಅದು ಅನ್ವಯ ಆಗುತ್ತೆ. ಇನ್ನ ಪ್ಲೀಡಿಂಗ್ಸ್, Order 6, pleadings generally. Order 7, plaint. Order 8, written statement. Briefly, to examine these provisions, which we are all using it, fundamental principles, facta probanda, facta probantia, which means we should only state fact, and those facts have to be stated briefly and relevant facts only be stated. ಬರೀ ವಿಷಯಗಳನ್ನ ಮಾತ್ರ ಹೇಳಬೇಕು, ಅದು ಸಂಬಂಧಪಟ್ಟಂತ ವಿಷಯಗಳನ್ನ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಹೇಳಬೇಕು. No need to mention about the evidence or law, except where the plaintiff wants to take the help of any provisions or limitation act if it is filed belatedly. Of course, as we know that for each type of suit, a different period of limitation is mentioned, given in the Limitation Act. And normally, I feel in the villages, especially, the suit for mortgages, foreclosure, and redemption has not been properly recognized because the period of limitation is 30 years, as we all know that. Similarly, for suits filed by government or any suit, that is what it mentions under Article 112 of the Limitation Act, is 30 years. Any suit by government, the period of limitation is 30 years under Article 112. So we should be very careful whenever we are going to file the suit or prepare the suit, whether we have got a cause of action or not, whether the suit is maintainable before the civil court or not, and whether it is within time, period of limitation. So then we can take advantage of other provisions, except, of course, Section 5, which is not applicable for filing of the suit, Section 12 to 23, I think, which we can make use of depending upon the nature of the suit, like payment of, recovery of money, or Section 18, 19, 20 can be taken help for excluding the time. Similarly, knowledge, Section 17 of the Limitation Act. So, except those circumstances, there is no need to mention about the law nor evidence. That is what the law of pleadings says. And in Order 6, Rule 4 becomes very important, where it says, if any fraud is alleged, otherwise, and it has to be proved, there should be plea and proof with regard to Order 6, Rule 4. The latest judgment you can see under Order 6, Rule 4, 2022, Supreme Appeal Reporter, within brackets civil, page 115. 2022, Supreme Appeal Reporter, civil, page 115. Party's name, Placido Francisco Pinto by Lors. I will repeat, Placido Francisco Pinto by Lors versus Jose Francisco Pinto and others, where the Supreme Court has in detail has analyzed with regard to Order 6 Rule 4 and held that there should be a plea in detail when the fraud was played. How all those details should be there in your pleadings, and to substantiate that pleading, there should be proof by way of evidence. That's what it says. So, another important provision is without pleadings, any amount of evidence will not be useful. Court cannot look into that. Therefore, the pleadings becomes very, very important. They are the foundation. Without pleadings, if you lead any evidence, court cannot look into. The opposite party may object that. So we should be very careful while preparing our pleadings. And 17, Order 6/17, amendment, which is also amended. Earlier, the amendments were allowed in the pleadings, that means plaint and return statement, at any stage which has been stretched to the stage of Supreme appeals pending before the Supreme Court. That is why they have thought of amending Order 6/17. Even then, they have given some proviso because of the lack of awareness about law in the people. There is a lack of knowledge of our right, where it says before evidence the pleadings can be amended. But in some cases where the parties, either the plaintiff or the defendant, satisfy the court, he was prevented from any reasons beyond his knowledge. He could not seek these amendments in spite of his due diligence. ಅವನು ಎಷ್ಟೇ ಎಚ್ಚರಿಕೆಯಿಂದ ಇದ್ರೂ ಈ ತಿದ್ದುಪಡಿಯನ್ನ ಸಾಕ್ಷಿ ವಿಚಾರಣೆಕ್ಕಿನ ಮೊದಲು ಕೇಳಕ್ಕಾಗ್ಲಿಲ್ಲ ಅಂತೇಳಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮನದಟ್ಟು ಮಾಡಿಕೊಟ್ರೆ ಮಾತ್ರ the court may allow the amendments. Of course, fortunately, the courts are taking very lenient view, including the Supreme Court. But as the Code of Civil Procedure is amended very recently in 2015 by another enactment which we are all familiar with or know, Commercial Courts Act. Order 8 is also amended, where the time is extended up to 120 days. Then it went to the Supreme Court, whether after 120 days in commercial disputes which are tried by the commercial courts under the Commercial Courts Act, can extend the time limit for filing the statements after 120 days. And the Supreme Court has very clearly held that no question of extending time for filing the written statement in the commercial disputes by the commercial courts. Only 120 days is the maximum. Beyond that, the courts cannot permit the defendant in a commercial suit disputes beyond 120 days. But at the same time, the Supreme Court has also made clear that as far as the disputes other than the commercial cases, the court has got power to extend beyond 90 days. That is because of Salem Advocates Association versus Union of India case, where the Supreme Court held that the word shall cannot be used in the sense, has not been used or cannot be taken into consideration as a dictionary meaning, as a mandatory. It is only a directory. ಅದು ಕಡ್ಡಾಯ ಅಂತ ನಾವು ತಗೊಳ್ಳೋ ಹಾಗಿಲ್ಲ. ಶಲ್ ಅನ್ನೋ ಪದವನ್ನ ಅದು ನ್ಯಾಯಾಲಯದ ವಿವೇಚನೆಗೆ ಬಿಟ್ಟಿದ್ದು. Court can permit the parties to file the return statement even after 90 days. So the Supreme Court has made it very clear, only in case of commercial disputes, time cannot be extended and order it to file the return statement. So that is with regard to filing of the return statement. But as far as the amendment of pleadings is concerned, same analogy has to be applied and as provided in Order 6/17, where the court has to look into whether the proposed amendment changes the nature of the suit or cause of action. Any right is accrued to the defendant if the plaintiff, if the defendant is seeking for the amendment, plaintiff seeking the amendment, vice versa. If the right is accrued and the amendment is not required for adjudication of the dispute effectively and judiciously, and cause of action is changed, then no question of allowing the amendment. These are the grounds on which the court will allow or refuse to allow the amendment of the pleadings under Order 6 to 17. Once the amendment is allowed, then Order 6 to 18 comes into picture, which we have to follow, that is carrying out of the amendment within 14 days. That is a must. Within 14 days, we should carry out the amendment. Now, plaint and return statement. Coming to the plaint and return statement. That's why I always say that if you remember the contents of a plaint, you can remember most of the provisions of the Code of Civil Procedure. ವಾದಪತ್ರದ ಅಂಶಗಳನ್ನ ನಾವು ನೆನಪಿನಲ್ಲಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಸಿವಿಲ್ ಪ್ರಕ್ರಿಯಾ ಸಮಿತಿಯಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಬಹಳಷ್ಟು ಕಲಮು ಮತ್ತು ಆದೇಶಗಳನ್ನ ಜ್ಞಾಪಕದಲ್ಲಿ ಇಟ್ಕೋಬಹುದು. So the plaint, cost title, body of the plaint, cause of action, limitation, court valuation, prayer, if it is pertaining to immobile property, schedule. So here itself, we will examine the jurisdiction of the court, because we have to mention the name of the court, name of the parties, and the jurisdiction of the court to try a case, for which we have to examine section 9, section 15 to 25, which includes transfer of the suits. Jurisdiction is concerned pecuniary jurisdiction, territorial jurisdiction, subject jurisdiction. Section 9 speaks about the subject jurisdiction. Section 6 of the Code of Civil Procedure speaks about the pecuniary jurisdiction. Section 15 to 21, capital A, speaks about territorial jurisdiction. So as we know that Civil Judge Junior Division has got pecuniary jurisdiction up to 5 lakhs. Above that, there is no upper limit as far as Civil Judge Senior Division is concerned. Then comes District Court, which does not have original jurisdiction in our court, on our state. So also High Court. In some of the states, High Court has got original jurisdiction like Madras and Bombay. But in our state, we do not have. Our High Court does not have the original jurisdiction to file original suits. And next, the Supreme Court. Territorial jurisdiction. 15 says a civil suit has to be filed before the lowest court, which is competent to try. So naturally, below 5 lakhs, Civil Judge Junior Division. Above 5 lakhs, Senior Division. So if it is above 5 lakhs, naturally the lowest court which is competent to try is Senior Division. 16, 17, 18, they deal with regard to the immobile property, suits pertaining to immobile property. A suit pertaining to immobile property has to be filed in the place where the property is situated, section 16. If the properties are situated in more places than one, in any one of the places, choice is of the plaintiff under section 17. If he is having a doubt, he is not sure in which court the case has to be filed, then section 19 says in any one of the court, he can file the suit which has got jurisdiction, then court should record that court also has got a jurisdiction. Once the court records that it has got jurisdiction, then the opposite side cannot raise objection. The court will proceed. Section 18, where the plaintiff is having doubt with regard to the jurisdiction of the case pertaining to immobile property. Because as I said, if the suit is, the land is situated on the border of two districts, then we'll be having a doubt in which place the case has to be filed. And such circumstances, section 18 is the answer. Other than the suits pertaining to immovable property, wrong done to a person or thing, where such cases have to be filed. Section 19. So, if the two persons start fighting in which one of the party gets hurt, his leg is fractured, he is admitted to the hospital, he loses his property, car, to the extent of which is valued, a new car, 10 lakhs. So naturally, two cases will be there. One is criminal case, another is civil. As far as civil case is concerned, those cases where it has to be filed is covered under section 19 of the Code of Civil Procedure, where it says where that incident has taken place. ಅವ್ರು ಎಲ್ಲಿ ಇಬ್ರು ಹೊಡೆದಾಡಿದ್ರು, ಎಲ್ಲಿ ಅವನಿಗೆ ಗಾಯ ಆಯ್ತೋ, ಕೈ ಕಾಲು ಮುರಿತೋ, ಅವನ ವೆಹಿಕಲ್ ಹಾಳಾಯ್ತೋ, ಆ ಜಾಗದಲ್ಲಾದ್ರೂ ಹಾಕ್ಬೋದು, ಆರ್ ವೇರ್ ದ ಡಿಫೆಂಡೆಂಟ್ or defendants are residing, ಅಲ್ಲಾದ್ರೂ ಹಾಕ್ಬೋದು. Apart from these types of cases, other cases where they have to be filed. As I used to say, this will create some confusion because of the more choices of places, like sale of goods. The seller will be in one place, purchaser is in another place, seller is in Bangalore, purchaser is in Hubli. They will enter into a contract in Belgaum. Then the goods are delivered as per the agreement in Bombay. The surety is in Kerala, Ernakulam. So by virtue of that agreement, the vendor supplies the goods worth 50 crores. Purchaser gives the advance 25 crores. Balance 25 crores to be given by the purchaser. Fails to pay the balance consideration. Seller is in Bangalore. Purchaser is in Hubli. Goods were delivered in Belgaum. Surety is in Chennai or Trivandrum, Ernakulam. So the vendor who is in Bangalore has to file a case. If he files a case for recovery of 25 crores in Bangalore City Civil Court, the defendant raises an objection under Order 7 Rule 10. This court has no jurisdiction to try this case. The court will hear that. If it comes to the conclusion, naturally it has to order for return of the plaint, Order 7 Rule 10. So, in view of the judgment of the High Court, Karnataka High Court, Justice Kumar, we have to raise this objection with regard to jurisdiction under Order 7 Rule 10 in our written statement only. If we cannot file an application, that is what the court says. There is no scope for filing an application under Order 7 Rule 10. If at all you want to raise an objection, then you have to raise that objections in your written statement itself. In addition to that, Section 21 says, if the defendant wants to raise objections with regard to the jurisdiction of the court, there is territorial jurisdiction, please remember. Under Order 7 Rule 10, you can include pecuniary jurisdiction also. If you fail to raise objections as contemplated under Section 21, the defendant is prevented from raising that objection either in the revision or appeal or execution, unless he is prejudiced very much by such filing of the case in a court which does not have the territorial jurisdiction. ಅವನು ಸಿಕ್ಕಾಪಟ್ಟೆ ತೊಂದರೆ ಆಗಿದೆ ಅದರಿಂದ ಅಂತ ಅವನು ಸಾಬೀತ್ ಮಾಡಬೇಕು. Very rare that. Except that circumstances, in the other circumstances, it is not permitted. And section 21 capital A proceeds and further says, once the defendant fails to raise the objection and allows the suit to be decreed, then he has no right to file a suit challenging the decree on the ground the decree is passed by the court which has no territorial jurisdiction. Barodilla, section 21 capital A. But when such a objection is raised in this written statement, in view of order 7 rule 10, the court has to be satisfied. In this particular illustration, naturally, we have to see section 20 of the Code of Civil Procedure. To file such types of cases other than the one which are mentioned under section 17 to 19 are covered under section 20 of the Code of Civil Procedure, where it says all other cases have to be filed where the cause of action has arisen partly or fully, or where the defendant or defendant resides or carries on business. So that principle, that provision has to be, that section has to be applied to this case. ಅದನ್ನ ನಾವು ಅಪ್ಲೈ ಮಾಡಿದಾಗ, when we apply that section 20, naturally the cause of action has arisen where the contract was entered into and where the goods were delivered. ಅಲ್ಲಿ ಮಾತ್ರ ನಾವು ಹಾಕ್ಬೋದು vernaculum, or where the defendant is residing, defendants are residing. Purchaser is in Hubli, goods were delivered in Belgaum. Example I am giving. So if you apply this section 20, it is makes very clear, except Bangalore, where the plaintiff is carrying on his business and residing, in all other places the case can be filed. Where the surety is there, where the part of cause of action is there, contract was entered into and goods were delivered, in all those places the case can be filed, except the place where the plaintiff is, because that is excluded unless part of the cause of action arises in Bangalore. But normally the plaintiff can put forward one ground stating that no, in our contract there is a clause which says that all the dispute arising in our court. As we all know that such a clause is against to the section 20, therefore it is illegal clause. And the Supreme Court has also taken the view that parties cannot confer jurisdiction on the court which does not have jurisdiction. ಒಪ್ಪಂದದ ಮೂಲಕ ಪಕ್ಷಗಾರರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ವ್ಯಾಪ್ತಿಯನ್ನು ಕೊಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ, ಕಾನೂನಿನಲ್ಲಿ ವ್ಯಾಪ್ತಿ ಇಲ್ಲದಿದ್ರೆ ಅದನ್ನು ಕೊಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಹಾಗಾಗಿ in this particular situation and illustration, only the case has to be filed other than Bangalore and all other places. That is how we have to deal with regard to that. If the case can be filed in more than one place, then section 22 and 23 is applicable. 22 and 23 is applicable, where it says the defendants can make an application requesting for transfer of the case to another court where the court has got jurisdiction. It is a discretion of the court, remember, not as a matter of right. Defendant ಕೇಳಬಹುದು, ಅವನು ಸ್ವಾಮಿ ನನಗೆ ಇಲ್ಲಿ ಬರಕ್ ತೊಂದರೆ ಆಗುತ್ತೆ, ಬಾಂಬೆದಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕೇಸು, ನನಗೆ ಅಲ್ಲಿ ಓಡಾಡೋದಕ್ಕಾಗಲ್ಲ, ಅದು ಬಿಟ್ಬಿಟ್ಟು ನನಗಿಲ್ಲೇ ಹುಬ್ಳಿಯಲ್ಲಿ ಹಾಕಿದ್ರೆ ನನಗೆ ಅನುಕೂಲ ಓಡಾಡೋದಕ್ಕೆ. ನೋ, court will look into the fact that whether it is convenient to all the parties in the suit, then it will decide. That is how we have to deal with. Even in one of the cases, matrimonial cases, our High Court, invoking section 23, has held that a case can be transferred from the Bangalore to court to other state also, and it has allowed that because cause of action was available there also in Hyderabad in that particular case. Because unlike in these civil cases, a matrimonial under the Hindu Marriage Act has to be filed where the marriage was solemnized or where the defendant is residing, respondent, or where the couples resided lost. ಕೊನೆಗೆ ಎಲ್ಲಿ ಅವರಿಬ್ರು ಜೊತೆಯಾಗಿ ವಾಸವಾಗಿದ್ರು, ಎಲ್ಲಿ ಮದುವೆ ಆಯ್ತೋ, ಎಲ್ಲಿ ಪ್ರತಿವಾದಿ ವಾಸವಾಗಿದ್ದನೋ ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು. And they have amended that also, including the place of wife. ಈಗ ವೈಫ್ ಎಲ್ಲಿರ್ತಾಳೋ ಅಲ್ಲಿಯೂ ಹಾಕ್ಬೋದು. So she need not go to other places. She can file the case, matrimonial cases under the Hindu Marriage Act where she resides. That is the amendment. So ಹಾಗಾಗಿ under section 23, our Karnataka High Court transferred the case pending before the High Court, Bangalore Court to the Hyderabad Court. Apart from this situation, where the parties have got right to file the cases in different places, 24-25, party wants case to be transferred, but there are no other places pertaining to immobile property. It has to be filed where the property is situated, Bangalore. But I don't want the Bangalore. Can you ask for the transfer or any other cases? Section 24 gives right to the district court and high court. Section 25 gives right to the Supreme Court to transfer the case from one state to another state. Like, as we know that, I think section 406 of CRPC, where the Supreme Court has ordered for transfer of the case pertaining to Jayalalitha, who was the chief minister in that state, to the Karnataka state. Similar is the power under section 25 of the Code of Civil Procedure. And if the party wants the case to be transferred from one place to another place in a district, then section 24. If the party wants the case to be transferred from one district to another district, again also section 24 to the High Court. When you file a transfer petition in the High Court, it will be termed as a CP, civil petition of Kariki. So that is how we have to deal with regard to the place of suing under section 15 to 25, including the transfer. Now coming to the order 7, rule 7 and rule 11. Order 7, rule 10, we have examined. One addition to that is to order 7, rule 10. If the defendant has already appeared, then the plaintiff can file an application under order 7, rule 10, capital A, requesting the court, yes, this court has no jurisdiction. I am going to take back the plaint within 30th of April, and I am going to represent before the Hubli court within 6th of June. You fix the date for appearance of both the parties here itself. So that will save the time of the court. There is no need to again issue a summons from the court in which he is going to represent the plaint. Time will be saved. Similarly, if the order is challenged before the appellate court under order 43, where the order 7, rule 10 application is allowed, it is an appealable, but not an order passed under order 7, rule 10, capital A, it is not an appealable. So before the appellate court also, if the plaintiff realizes his mistake, he can make use of order 7, rule 10, capital B, same thing as in rule 10A, request the court to fix the date of hearing, appearance of both the parties, undertaking to take the plaint within a particular date, and promising the court or undertaking to the court that he is going to represent the plaint within a particular date. Illa date fix ಮಾಡಿ ಅಂತ ಕೇಳಬಹುದು. Order 7, rule 7 is a unique provision And similar provision is also there under Order 41, Rule 33, where the court has got power to grant the prayer by molding. Court can mold the prayer. That is what we call it. If the parties are there, but the court can grant the relief which is not sought for by the plaintiff. Normally, the court cannot grant the relief which is not sought. ಸಾಮಾನ್ಯವಾಗಿ ಆದರೆ ಕೆಲವು ಸಂದರ್ಭದಲ್ಲಿ ಎಲ್ಲಾ ಪಾರ್ಟಿಗಳು ಪಕ್ಷಗಾರರು ಅದರಲ್ಲಿದ್ದಾರೆ, ಅದರಿಂದ ಎಲ್ಲರಿಗೂ ಅನುಕೂಲ ಆಗುತ್ತೆ ಅನ್ನೋದಾದ್ರೆ ಇಟ್ ಕ್ಯಾನ್ ಇನ್ವೋಕ್ Order 7, Rule 7, for which we know that in a suit for declaration between the family members pertaining to an immovable property, if court comes to the conclusion that declaration cannot be granted to the plaintiff, if it feels that instead of declaration, the court can pass a decree for partition, invoking Order 7, Rule 7, court can mold the relief and decree the suit for partition instead of declaration. In Order 7, Rule 11, another important provision from the point of view of your examination, where the suit, the plaint can be rejected. Rejection of plaint is also termed as a decree. Section 2, subsection 2 defines what is a decree. Expression of the court by which it determines the rights of the parties conclusively, then only it becomes decree. If it is only passes an order, expresses its opinion, it is only an order. But by which it conclusively determines the rights of the parties, then it amounts to decree. And decree may be preliminary decree or final decree, or partly preliminary or partly final. So preliminary decree is one where the court will decide the right of the party. A final decree is one where the court will determine all the disputes between the parties. And Order 20 gives you the details under which type of suits the court can pass a preliminary decree, where we see partition cases, partnership cases, specific performance of the contract, and mortgages. Court is required to pass a preliminary decree, thereafterwards final decree. And for filing a final decree, there is no limitation as held by the Supreme Court. Rule 11, which is also amended, now there are 6 grounds for rejection of the plaint. A, Order 7, Rule 11A, if the defendant shows to the court the plaintiff has no cause of action to file the suit. The Supreme Court says to see whether the cause of action is there or not, the court is required to look into only plaint averments, not the written statement. Only plaint averments, and recently the Supreme Court has also held that the averments in the plaint has to be looked in totality, not in bits. ಸಂಪೂರ್ಣವಾಗಿ ಅದನ್ನು ಗಮನಿಸಬೇಕು ನ್ಯಾಯಾಲಯ ವಾದ ಪತ್ರವನ್ನ. ಅಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ಇಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ನೋಡಿ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಇದೆಯಲ್ಲ ಅಂತ ತೀರ್ಮಾನ ಮಾಡೋದಲ್ಲ ಅಂತ ಹೇಳಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ. The court has to look into the averments of the plaint in its totality, not in bits. Then it should, and it has reiterated, you need not go to the written statement to find out whether the cause of action is there or not. Second ground, suit should be properly valued and correct court fee should be paid. ಸರಿಯಾಗಿ ವ್ಯಾಲ್ಯೂ ಮಾಡಬೇಕು, ಆಮೇಲೆ ಸರಿಯಾದ ಕೋರ್ಟ್ ಫೀಸ್ ಕೊಡಬೇಕು. If it is not done, the court can reject the plaint. The third ground, the suit is valued properly, but court fees paid less deficit court fees. In spite of time granted by the court, if the plaintiff fails to furnish the deficit court fee, it can reject the plaint. Fourth and important is barred by any law. If the suit is barred by any law, then also the court will reject the plaint. But the Supreme Court has taken the view, if the defendant raises a plea of res judicata, an earlier suit was already decided, this prayer ought to have been prayed in that case itself. This is hit by res judicata, principles of res judicata. As we know that section 11, which deals with regard to the principles of res judicata, the matter in issue in the second suit is directly and substantially the same in the earlier suit, or collateral in issue in the earlier suit. Purva nirnita nyaya, res judicata ಕನ್ನಡದಲ್ಲಿ. ಈಗ ಹಾಕಿರ್ತಕ್ಕಂಥ ವ್ಯಾಜ್ಯದಲ್ಲಿರ್ತಕ್ಕಂಥ ಅಂಶಗಳು ಫ್ಯಾಕ್ಟ್ಸ್ ಇನ್ ಇಶ್ಯೂ ಮೊದಲೇ ಹಾಕಿದ ಕೇಸ್ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಅಂಶಗಳು ಡೈರೆಕ್ಟ್ಲಿ ಅಂಡ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲಿ ಸೇಮ್, ನೇರವಾಗಿ ಪ್ರಮುಖವಾಗಿ ಅದೇ ವಿಷಯಗಳು ಅದರಲ್ಲಿ ಇದ್ವು. ಹಾಗಾಗಿ ಆ ಕೇಸ್ ತೀರ್ಮಾನ ಆಗಿದ್ರೆ ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. res judicata. Section 11 embraces almost all types of cases. 5 ಲಕ್ಷಕ್ಕೆ ಒಂದು ಕೇಸ್ ಹಾಕಿದ್ದ, ಬಾಡಿಗೆ ಕೊಡಬೇಕು 3 ವರ್ಷದ್ದು, 2009, 2010, 2011 ವಜಾ ಆಯ್ತು, ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ ಟೆನೆಂಟ್. ಮತ್ತೆ ಅದೇ 3 ವರ್ಷಕ್ಕೆ ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕಿದ್ದಾನೆ. ಡೈರೆಕ್ಟ್ಲಿ ಅಂಡ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲಿ ದ ಸೇಮ್ ಇಶ್ಯೂ ದೇರ್ ಇನ್ ದ earlier case. But if the issue is only collaterally in issue in the earlier case, ಈಗಿನ ಕೇಸ್ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಅಂಶ ಸಾಂದರ್ಭಿಕವಾಗಿ ಮೊದಲನೇ ಕೇಸ್ನಲ್ಲಿ ಇತ್ತು ಸ್ವಾಮಿ, ನೇರವಾಗಿ ಇರಲಿಲ್ಲ, ಹಾಗಾದ್ರೆ res judicata ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. An earlier suit was filed for recovery of rent. Defendant took up a contention. ಇಲ್ಲ ಸ್ವಾಮಿ, ನನಗೆ 40-60 ಸೈಟ್ ಬಾಡಿಗೆ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದ, ಕೊಟ್ಟಿರೋದು ಬರೀ 20-20, ಹಾಗಾಗಿ ಅದಕ್ಕೆ ಸರಿ ಹೋಯ್ತು, ಬಾಡಿಗೆ ಕೊಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. Incidentally, the court will give a finding that 2020 only given. The plaintiff files one more suit for eviction or declaration of his title for 40-30. Defendant, if we take a contention, earlier suit nalli idagoಗಿದೆ, then the court, if it is satisfied on the argument of the plaintiff, that was only a collateral issue, that was not the main issue which was decided. In a small cause court that was done. Small cause court ಗೆ ಡಿಕ್ಲರೇಷನ್ ತೀರ್ಪನ್ನು ಕೊಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಒಂದು ಇದು ಸಾಂದರ್ಭಿಕವಾಗಿ ಅದು ತೀರ್ಮಾನ ಕೊಟ್ಟಿದೆ ಅದರಲ್ಲಿ, ಹಾಗಾಗಿ it is collateral issue, therefore res judicata is not applicable. In this directly and substantially an issue is subdivided. Actually the same issue was there in the earlier suit also, and it was constructively the same issue was there in the earlier case. Bifurcate ಮಾಡಿದ್ದಾರೆ. Actually the same issue was there. ಇದೇ ವಿಷಯವನ್ನ ಆ ವ್ಯಾಜ್ಯದಲ್ಲಿ ತೀರ್ಮಾನ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ನಾನು ಯಾವಾಗಲೂ ಉದಾಹರಣೆ ಕೊಡ್ತಾ ಇದ್ದೆ, ನಿಮಗೆ ಗೊತ್ತಿದೆ. ಒಂದು ಕ್ರಯ ಪತ್ರದಲ್ಲಿ 3 ಆಸ್ತಿಗಳನ್ನು ಕೊಂಡ್ಕೊಳ್ತಾನೆ. ಕೊಂಡುಕೊಂಡು ಒಂದು ಆಸ್ತಿಯ ಬಗ್ಗೆ ಮಾತ್ರ ಕೇಸ್ ಹಾಕ್ತಾನೆ. ಪ್ರತಿವಾದಿ took up a contention, no, this sale deed is created, fraudulently made, it is null and void. That was upheld by the court. ಕೋರ್ಟು ಕರೆಕ್ಟ್, ಅದು ಕ್ರಿಯೇಟ್ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು ಫೋರ್ಜ್ ಆಗಿರ್ತಕ್ಕಂಥ ಡಾಕ್ಯುಮೆಂಟು, ಅದಕ್ಕೆ ಕಾನೂನಿನಲ್ಲಿ ಮಾನ್ಯತೆ ಇಲ್ಲ ಅಂತ ವಜಾ ಮಾಡುತ್ತಾ ಕೇಸನ್ನು. The A files one more case based on the very same sale deed pertaining to another property. Then the defendant takes up a contention. The actual issue with regard to the validity of sale deed is already decided in the earlier suit. Therefore, second suit is not maintainable. Actually, the same issue was there. Constructively the same. ಅದಕ್ಕೆ ನಾನು ಯಾವುದು ಪೊಲೀಸ್ ಆಫೀಸರ್ ಎಕ್ಸಾಂಪಲ್ ಕೊಡ್ತೀನಿ, ಬಹಳ ಸುಲಭ ಅದು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋಕೆ ಅಂತ ಹೇಳಿ. He will be terminated. Police officer will be terminated. He challenges that order before the High Court by way of writ. On the ground, no opportunity was given. ತನಗೆ ಸರಿಯಾದ ಅವಕಾಶ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. The department produced all the documents for having given me more than sufficient opportunity before he was terminated. Court will dismiss his writ petition. ಕೊಟ್ಟಿದ್ದಾರೆ ನಿನಗೆ ಸಾಕಷ್ಟು ಅವಕಾಶ ಅಂತ ಹೇಳಿ. He files one more suit. The police officer with an additional ground that I was appointed by IG, but removed by the additional IG. ನನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದು IG ಅವರು ಅಡಿಷನಲ್ IG ತೆಗೆದಿದ್ದಾರೆ, ಹಾಗಾಗಿ ಇಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಟು ದಿ ಸರ್ವಿಸ್ ರೂಲ್ಸ್, ಸಿವಿಲ್ ಸರ್ವಿಸ್ ರೂಲ್ಸ್ ವಿರುದ್ಧ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. Then the defendant police department takes up the contention. It is hit by principles of constructive res judicata. ಅಂದ್ರೆ ಸ್ವಾಮಿ ಈ ಗ್ರೌಂಡ್ ಅವನಿಗೆ ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ವಾಸ್ ಅವೈಲಬಲ್ ಟು ಹಿಮ್. ಅವನಿಗಿದು ಈ ಗ್ರೌಂಡ್ ತಗೋಬೋದಾಯ್ತು. ಅವನು ತಗೊಳ್ಳದೇ ಇದ್ದಿದ್ರಿಂದ law presumes he has raised that ground and court has refused. That is called as constructive res judicata. It will presume he has raised that ground and court has refused that ground also. And the case was dismissed. Ultimately, it went to the Supreme Court. Supreme Court upheld the contention of the department. Yes, it amounts to constructive res judicata. So like that, if you take up a contention of res judicata is made applicable not only to the suits, even to the writ petitions, even almost all types of cases it is made applicable, and even execution also it is made applicable, and public interest litigation. Only thing is between the same parties or persons claiming through them, and the relief claimed in the second suit could have been claimed in the earlier suit also, and the earlier suit should have been heard and decided. Ex parte as barala, ex parte dismiss for non-prosecution barala. On merits, court should have heard and decided the matter. Then only you can apply. When such a plea is raised in the written statement, or if a person files an applicant, the court was considering such a plea, can it be invoked under Order 7, Rule 11? Same is the situation where the defendant raises objection with regard to limitation. Suit is barred by limitation. Supreme Court has held in many cases, since the question of res judicata requires consideration of pleadings, issues, and the decision made in the previous suit. Therefore, it cannot be taken as a ground under Order 7, Rule 11. So also Order 14, Rule 3, where we can seek for hearing of a particular issue as a preliminary issue, for which you can look into decision, a recent decision, Order 7, Rule 11, res judicata ಬಗ್ಗೆ 2021 Supreme Appeal Reporter within bracket civil, page 956, party's name Sri Hari Hanuman Das Totala versus Hemant Vittal Kamath and others. With regard to cause of action, you can note another decision of Supreme Court recently held, pertaining to a partnership act. 2021 SAR within bracket civil page 1053 Rajendra Bajoria and others versus Hemant Kumar Jalan and others, where the Supreme Court held that one of the partners filed a suit alleging the violation of provisions of section 42, 43 and 48, suit for accounts, dissolution of the partnership firm. The court found that there is no cause of action to file such a suit, and therefore the plaint can be rejected under Order 7 Rule 11A of the Code of Civil Procedure. Of course, as far as the limitation is concerned, that also the court has held that the question of limitation is a mixed question of fact and law. Therefore, it requires evidence. It cannot be considered as under Order 7 Rule 11. So also under Order 14 of the Code of Civil Procedure as a preliminary issue. Barring certain circumstances where the Supreme Court has also held that if the suit is hopelessly barred on the face of it, then court can invoke and hear that as a preliminary issue. Adunu madidare Supreme Court. Otherwise, normally the court cannot. That is how we have to deal with regard to Order 7 Rule 11D. If the suit is barred by any law, the plaint can be rejected. Other two grounds, E and F, which are introduced by way of amendment of 1999 and 2002. One is, as we know, that if the plaint is filed not in duplicate, the plaint can be rejected. Similarly, if the plaintiff fails to furnish as many copies as there are defendants, as mentioned under Order 7 Rule 9 of the Code of Civil Procedure, then also the plaint can be rejected. ಎಷ್ಟು ಜನ ಪ್ರತಿವಾದಿ ಇದ್ದಾರೋ ಅಷ್ಟು ಜನಕ್ಕೆ ಪ್ರತಿಗಳನ್ನು ಕೊಡಲೇಬೇಕು. ಕೊಡದೇ ಇದ್ರೆ ಈಗ ರಿಜೆಕ್ಟ್ ಮಾಡಬಹುದು. ಮೊದಲಿರ್ಲಿಲ್ಲ. ದ್ವಿಪ್ರತಿ ಹಾಕದೇ ಇದ್ರು it can be rejected. Of course, even the plaint is rejected since it is termed as a decree under Order 2. It is called as deemed decree, even though it will not fit into the definition of Order Section 2, subsection 2, because including, that is what Section 2, subsection 2 says, order passed under 7 Rule 11. Rejection of plaint is also termed as a decree. So also the order passed under Section 144, which deals with regard to restitution, that is also termed as a decree. So appeal is provided. So when it is decree, we can file an appeal under Section 96 coupled with Order 41 of the Code of Civil Procedure before the appellate court. Now coming to Order 8, in brief, which deals with regard to return statement. One, as far as time is concerned, we have already mentioned, for which you can look into the decision, commercial disputes and other cases, 2022 Supreme Appeal Reporter, Civil 256, the one which I mentioned, after 120 days, as far as commercial disputes are concerned, court cannot extend the time. In other cases, court can extend the time. 2022 SAR within bracket civil page 256, Shohraj Singh versus Charan Singh, not Shohraj Singh, noted criminal, Shohraj Allah, Shohraj Singh versus Charan Singh. Now, the defendant is required to traverse all the averments made in the plaint specifically. Whichever he does not admit specifically he should deny. ನಿರ್ದಿಷ್ಟವಾಗಿ ಅಲ್ಲಗಿಳಿಬೇಕು. It should not be evasive reply, denial. ಸ್ಪಷ್ಟವಾಗಿ ಅಲ್ಲಗಿಳಿಬೇಕು. If he fails to deny any of the allegations made by the plaintiff in his plaint, out of 8 Rule 5 says it is deemed to have been admitted. There should be specific denial. So also, if the defendant has got a separate case, after denying the allegations in the plaint, he should specifically state his case in a separate paragraph. That's what Order 8 says. If the defendant files a separate paragraph bringing a new facts which required to be answered, then comes Order 8, Rule 9 of the Code of Civil Procedure, where it says no further pleadings can be filed after the written statement without permission of the court. So if the defendant comes up with a new plea, then the plaintiff can invoke Order 8, Rule 9. With the permission of the court, he can file a rejoinder. Order 8, Rule 10 says, if the defendant fails to file the written statement, then court can proceed to decree the suit. Even though they say that decree the suit, courts have taken the opinion that if the court is doubtful, then it can ask the plaintiff to prove his case. Now, very interesting aspects of Order 8, other interesting aspects of the Order 8. Rule 6 and Rule 6 capital A, set off and counterclaim. If the defendant claims a set off, plaintiff himself is liable to pay me 10 lakhs in a suit filed by the plaintiff for 15 lakhs, then we can treat it as a set off because less than the claim made by the plaintiff. So the court has to decide both. 10 lakhs, whether the plaintiff is entitled or the set off claimed by the defendant. Court has to deal with both. 6A deals with regard to, but to seek for the set off, it should be money suit and ascertained sum, and the court in which he seeks for set off should have the jurisdiction to grant that. Then only that can be allowed. As far as 6A is concerned, the Supreme Court has taken the view, even in other types of cases also, the court can grant to the defendant a counterclaim. Very peculiar case came up before the Supreme Court, which is reported in 2022, Order 8, Rule 6 capital A. Supreme Appeal Reporter 2022, within bracket civil, party's name Neeta Bain, Dinesh Patel. Neeta Bain, Dinesh Patel versus Dinesh Dhaya Bhai Patel. Dinesh Dhaya Bhai Patel. Where the wife, the respondent, sought for counterclaim and Order 8, Rule 6 capital A for a declaration to declare that the marriage of her husband with a third party is null and void. Wife, who was the respondent, sought for a declaration to declare the marriage between her husband and a third woman is null and void. The Supreme Court, even though in other cases the Supreme Court has taken the view that even in a suit for injunction, the counterclaim can be made. Here, the Supreme Court, after examining the provisions of Hindu Marriage Act particularly section 23 capital A, which permits the parties to seek for counterclaim, held that you can seek for counterclaim in a matrimonial case under the provisions of the Hindu Marriage Act, which are permissible under the Act, but not the one which are not permissible. For that, they gave an example. You have got right to seek for section 9, like restitution of conjugal right, 10, 11, 12, and 13, divorce. Those are available. You can seek for counterclaim under any of those provisions, but not the relief which is not provided under the Hindu Marriage Act. There is no provision under the Hindu Marriage Act which gives the right to the parties for declaration of nullity of a marriage with a third party, second marriage or whatever it may be. So therefore, the Supreme Court has said that no, you cannot seek such a relief by way of counterclaim under the provisions of the Hindu Marriage Act. Now, to seek for the counterclaim, again, the court should have the power to grant you the counterclaim. You are required to pay the court fees. Under orders A8 Rule 6 capital A to F G, it gives how the counterclaim has to be treated. Once the counterclaim is filed by the defendant, it becomes the plaint, and the plaintiff has to file the written statement. And the court has to frame issues on both plaintiff pleadings as well as counterclaim pleadings. Court is required to decide both. Even when the plaintiff fails to lead his evidence to prove his claim, relief, the court is bound to deal with regard to counterclaim made by the defendant and pass the appropriate decree, which can be executed. So, in a nutshell, that is how we have to deal with regard to counterclaim provided under Order 8 Rule 6 capital A of the Code of Civil Procedure. Once the written statement is filed, next, the consequences of appearance and non-appearance are provided under Order 9. 10 deals with regard to examination of the parties and alternative dispute resolution mechanism, coupled with section 89. Thereafterwards, the framing of issues, Order 14, and then comes production of documents under Order 13, and 15 deals with regard to disposal of the suit at the first hearing, 16 summoning of the witnesses, 17 adjournment, 18 hearing of the suit, which is also very, very important, and comes Order 20, which deals with regard to judgments. Now, the consequences of appearance and non-appearance of the parties provided in Order 9, very briefly to state, in the initial stage, if the plaintiff remains absent, there is no worry. He has failed to pay the process fee or failed to appear and seek for time, suit is dismissed for non-prosecution at stage, then Order 9 Rule 1 and 3, they comes into picture. He can seek for restoration of the suit, or he can file a fresh suit on the same cause of action. Similarly, if the defendant, after due service of the summons, remains absent and is placed ex parte, Order 9 Rule 6, then comes Rule 7, Order 9 Rule 7. On the next date of hearing, if the case is still pending, he can make use of and file an application for setting aside the ex parte order under Order 9 Rule 7. But Rule 8, Order 9, where it says, if the plaintiff remains absent, the defendant are present, the court can proceed to dismiss the suit for non-prosecution. That is the dangerous stage because Order 9, Rule 9 says, once the suit is dismissed for non-prosecution and Rule 7, where the plaintiff only remained absent, defendant is present, the plaintiff is precluded from filing a fresh suit on the same cause of action. ಅದೇ ವ್ಯಾಜ್ಯದ ಕಾರಣದ ಮೇಲೆ ಹೊಸ ವ್ಯಾಜ್ಯವನ್ನು ಹಾಕೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. Only remedy available to the plaintiff is he has to file a miscellaneous petition under Order 9, Rule 9 within 30 days. If it is delay, Section 5 of the Limitation Act, and he has to get it restored. Then Order 9, Rule 13. If the defendant remains absent continuously and allows the suit to be decreed ex parte, then the defendant has got right to either file an appeal under Section 96, or he can invoke Order 9, Rule 13 of the Code of Civil Procedure to get it set aside. Normally we will file miscellaneous petition because there is no court fees required to be paid, unlike in an appeal under Section 99 coupled with Order 41. And we will have more opportunity before the trial court itself in miscellaneous by leading evidence. And if anything happens, if our application is rejected, then it is an appealable order under Order 43 of the Code of Civil Procedure. Rejection of an application filed under Order 9, Rule 13 is an appealable order. So also an application filed under Order 9, Rule 9, if it is rejected, it is an appealable order. So therefore we file a miscellaneous petition under Order 9, Rule 13 of the Code of Civil Procedure. Next, once the written statement is filed, Order 10 says court has got power to ask questions. It can examine any of the parties. The answers given by the parties under Order 10 will form part of the record and have to be seen while framing the issues under Order 14 of the Code of Civil Procedure. That's what Order 14 says. In addition to that, Section 89 and Order 10 further says court has to ask the parties the possibility of the settlement. So if the parties are agreeing for settlement, they should give the terms. What are the terms for settlement? And options are given. They can choose any option: mediation, conciliation, Lok Adalat, Legal Services Authority Act, arbitration, and even the court can ask them to come to the chamber and settle the matter. Any one of the modes as desired or selected by the parties. Once they select any mode, then Order 10 says the same act has to be applied. If the parties decide their disputes can be settled by arbitrator, then as per the provisions of the Arbitration Act, that has to be solved. If the mediation, conciliation, arbitration, Lok Adalat is failed, then it has to be returned to the court. So there is no compulsion. It is a good idea to persuade the parties to settle the matter so that they can go with a smile without grouse or without hatredness. To a little extent, if the matter is settled, it is a good thing for them to keep the relationship intact, especially in our partition cases. Then comes the 13 deals with regard to production of the document. So as we know that when the documents are produced, now in view of the amendment to Order 7 and Order 8, you are now required to produce the documents along with the plaint and written statement itself. Even if there is a delay, fortunately, the proviso says that with the permission of the court, we can file the documents belatedly also. Normally, the courts will allow or permit the parties to produce the document. When the documents are produced, The courts have got power, and the parties are also have got right to object. If they are insufficiently stamped, the court has got power to impound the document and refer to the DC for stamps to find out what is the correct code. Stamp duty has to be paid. So if the party wants to rely on that particular document which is insufficiently stamped, has to pay the duty and penalty as determined by the DC for stamps and valuation. If you want to rely on that, which will be very costly affair. The penalty can be imposed 10 times of the deficit stamp duty, maximum. And if it is irrelevant document, they can object. It is an irrelevant document. Court itself can object. It is an irrelevant document. And you can seek for return of the documents which are rejected, or with the permission of the court by producing the certified copy, and after the disposal of the suit and after the appeal period is over, then also. If the document is lost its value, then there is no question of return of documents under Order 13. That is what it says. Sometimes it may happen that the documents which has been produced will lose its value in a probate and succession case, where will is required to be probated and original will be produced. When the probate is given on the stamp paper as per the provisions of the Indian Succession Act, the original will loses its value. The probate will be replaced. So under such circumstances, the original documents may not be given in view of the Order 13 of the Code of provisions of the Order 13 of the Code of Civil Procedure. Then comes 14, another important provision from the point of view of your examination. Which deals with regard to framing of the issues within 7 days, which is next to impossible. The courts will be very stressed. It depends upon the nature of the case, suit. If it is only a recovery of money, few issues will be there. On the other hand, if it is a complicated suit, usementary rights, specific purpose of the contract, partition suit, mortgages, so on and so forth, it is very difficult for the court to frame the issues within 7 days. The issues are of different kinds, as we know: issue of fact, issue of law, issue of mixed question of fact and law. Issue of fact is one which is only pertaining to facts. ವಿಷಯಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ವಿವಾದಾಂಶಕ್ಕೆ issue of fact ಅಂತ. If it is pertaining to a law, ಕಾನೂನಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತದ್ದಾದ್ರೆ it is issue of law. ಕೆಲವು ವಿವಾದಾಂಶಗಳು ಎರಡನ್ನೂ ಒಳಗೊಂಡಿರ್ತವೆ, like law of limitation, question of limitation, which is mixed question of fact and law. That is issue of mixed question of fact and law. How these issues have to be framed is also provided under the Order 14. And what is the issue? What do you mean by issue? An issue is one where a material proposition of fact is affirmed by one party and denied by another party is an issue of fact. A material proposition of law affirmed by one party and denied by another party is an issue of law. So if you say that defendant is liable to pay 50 lakhs, then it is issue of fact which is denied. It is a material proposition affirmed by the plaintiff. He is liable to pay me 50 lakhs. Defendant denies. This defendant denies that he is liable to pay 50 lakhs or any amount to the plaintiff. Issue of fact. Issue of law. The plaintiff says the defendant has executed a promissory note while receiving the 50 lakh rupees. The defendant says the alleged promissory note is not executed by this defendant, much less it is materially altered. In view of section 87, it is invalid. ಅದನ್ನು ಆಲ್ಟರ್ ಮಾಡಿದ್ರೆ materially it is altered. So once it is materially altered, it has no value in the eye of law because of section 87 of the NI Act, Negotiable Instrument Act. So it is affirmed by the one party, it is lawfully valid, has executed promissory note. No, it is materially altered, it is not valid. It is the issue of law. Since law of limitation, question of limitation requires evidence also, it is known as mixed question of fact and law. So how these issues have to be framed? Article 14 says to 2, the court has to consider the pleadings, plaint and return statement, documents produced by both the parties, and answers given by the parties in the examination under Order 10 of the Code of Civil Procedure. ಇದನ್ನೆಲ್ಲ ಗಮನಿಸಿ ನೋಡಿ ನ್ಯಾಯಾಲಯ ವಿವಾದಾಂಶಗಳನ್ನು ರಚಿಸಬೇಕು. ವಾದಪತ್ರ ಮತ್ತು ಪ್ರತಿವಾದ ಪತ್ರಗಳನ್ನು ನೋಡಬೇಕು, ದಾಖಲೆಗಳನ್ನು ನೋಡಬೇಕು, ಮತ್ತೆ ಪಕ್ಷಗಾರರು ಕೊಟ್ಟಂತ ಉತ್ತರಗಳು ಆದೇಶ 10ರಲ್ಲಿ ನ್ಯಾಯಾಲಯ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾಗ ಉತ್ತರ ಕೊಟ್ಟಿದ್ರೆ ಆ ಉತ್ತರಗಳನ್ನು ನೋಡಿ ವಿವಾದಾಂಶಗಳನ್ನು ರಚಿಸಬೇಕು. That's what it said. In addition to that, the court has also got power to ask the parties to produce certain persons to examine, to ascertain what exactly the issues between the parties. The issues are nothing but the point of dispute between the parties. ಅವರು ಇಬ್ಬರ ಮಧ್ಯೆ ಇರತಕ್ಕಂತ ವಿವಾದ ಏನು? What are that will enable the court and also the parties to lead their evidence and through the court to give the judgment. But actually the dispute is between the parties. Those are the issues. ಅವ್ರ ಇಬ್ರು ಬಗ್ಗೆ ಇರತಕ್ಕಂತ ವಿವಾದ ಏನು ಮುಖ್ಯವಾದ ವಿವಾದ ಅದನ್ನ ಇಶ್ಯೂಸ್ ಅಂತ ಕರಿತೀವಿ, ವಿವಾದಾಂಶ. And these issues, when it is framed, the court can permit the parties to argue on a particular issue as a preliminary issue. ಅದನ್ನು ಮಾಡಬಹುದು. ಪ್ರಾಥಮಿಕ ವಿವಾದಾಂಶವನ್ನಾಗಿ ಪರಿಗಣಿಸಿ ಅದನ್ನ ಮೊದಲನೇ ತೀರ್ಮಾನ ಮಾಡಬಹುದು. If court feels that a particular issue goes to the root of the case and if it is decided, then other issues need not be considered. But Order 14 says only issues of law can be heard as a preliminary issue, not issue of fact. Only issue of law can be heard as a preliminary issue. And Rule 4 says, and 5, the court has got power to amend the issues. Either it can modify the issue, it can delete the issue, it can frame additional issue. Court can also do that. Parties also can file an application for deletion, addition, modification of the issue. Adunu ಮಾಡಬಹುದು. At any stage before passing of the decree. That is what the word they have used. Court has got that power. And based on the agreement, Rule 6 and 7 of Article 14 gives power to the court based on the agreement of the parties. If it is voluntarily made, it is a genuine agreement. If the parties submit themselves like in a suit which is known as friendly suits under Order 36 of the Code of Civil Procedure, special case, which is also known as special case, court can frame issues and deal with this. Since the parties submit themselves to the court jurisdiction under Order 36 as a special case, once the suit is once the case is decided by the court on order 36, no appeal is provided. No appeal is provided. So once the issues are framed, then course the parties are required to file their list of witnesses and documents within 15 days. And section order 16 deals with regard to summoning of the witnesses. Order 17 adjournment. Order 18 hearing of the suit. Court will decide the case. So order 18 becomes very, very important, because where it says the plaintiff has got right to lead his evidence first. ಅವ್ರಿಗೆ ಮೊದಲು ಆದ್ಯತೆ. Or
sorry for interrupt, sir.
Yes,
sir, I hope ಇನ್ನೂ ಒಂದು ಸೆಷನ್ ಬೇಕಾಗಬಹುದು ಅಂತ ಅನ್ಕೊಂತೀನಿ ಸರ್.
ಹೌದಾ?
ಅಲ್ಲ ಸರ್, ಯಾಕಂದ್ರೆ ತಾವು ಬಹಳ ಸವಿಸ್ತಾರವಾಗಿ ನಮಗೆ ಎಲ್ರಿಗೂ ಅದು ಸಂಪೂರ್ಣವಾಗಿ ಮೈಂಡ್ ಅಲ್ಲಿ ಹೋಗುವ ರೀತಿ ಒಳಗಡೆ ಉಪನ್ಯಾಸ ಮೂಡಿ ಬರ್ತಾ ಇದೆ ಸರ್. ಬಹುಶಃ ತಮಗೆ ಇನ್ನೂ ಸಮಯ ಕನಿಷ್ಠ 1-1.5 ತಾಸು ಬೇಕಾಗ್ತದಲ್ವಾ ಸರ್?
ಏನ್ ಮಾಡೋಣ ಅಂತ ನಿಮ್ಮ ಸಜೆಷನ್?
ಸರ್, ನನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಸರ್, ಇನ್ನೊಂದು ಅವಕಾಶ ತಾವು ಕೊಟ್ರೆ ಇನ್ನೊಂದು ದಿವಸ ತಮ್ಮ ಪಾಠವನ್ನ ಮುಂದುವರಿಸಬಹುದು. ತಾವು ಉಪನ್ಯಾಸ
ಅದರಲ್ಲಿ ಬೇಕಾದ್ರೆ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಅಪೀಲು, ರಿವಿಷನ್, ರಿವ್ಯೂ ಅದನ್ನು ಕವರ್ ಮಾಡಬಹುದು.
ಪ್ಲೀಸ್ ಸರ್, ಯಾಕಂದ್ರೆ ಡಾಟಾ ಖಾಲಿ ಆಗ್ತದಂಗೆ ಇವರು ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಡೌನ್ ಆಗ್ತಾ ಹೋಗ್ತಾರೆ ಸರ್.
ಓಕೆ,
ಹಾಗಾಗಿ ಸರ್ ತಾವು ಒಂದು
ಸೊ ವಿ ವಿಲ್ ಸ್ಟಾಪ್ ಎಟ್ ದಿಸ್. We will deal with regard to the order 18 and order 16 also in the next session. And I sincerely thank the Bar Council for having given me this unique opportunity to share my views and discuss with you, and all the participants who have given me a patient hearing. Thank you very much.
Thank you, sir. Thank you so much. Sir, interaction ಮಾಡಬಹುದಲ್ಲ ಸರ್? ತಾವು ಇನ್ನೂ ಸ್ವಲ್ಪ ಸಮಯ ಕೊಡ್ತೀರಲ್ಲ?
ಮಾಡಬಹುದು.
ಆತ್ಮೀಯ ಬಂಧುಗಳೇ, ಇಲ್ಲಿಯವರೆಗೆ ನಮಗೆ ಗೌರವಾನ್ವಿತ ಜಗದೀಶ್ ಮುಂಡ್ರಗಿ ಸರ್ ತಮ್ಮ ಅಮೂಲ್ಯವಾದ ಸಮಯವನ್ನ ನಮ್ಮ ಜೊತೆಗೆ ಕಳೆದ 2 ಗಂಟೆಗಳ ಕಾಲ ನಿರಂತರವಾಗಿ ದಿವಾಣಿ ಪ್ರಕ್ರಿಯಾ ಸಂಹಿತೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಅತ್ಯಂತ ಸವಿಸ್ತಾರವಾಗಿ ನಮ್ಮೆಲ್ಲರಿಗೂ ಪ್ಲೇಂಟ್ ಅಂದ್ರೆ ಏನು, WS ಅಂದ್ರೆ ಏನು, ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಅಂದ್ರೆ ಏನು, ಅದ್ರ ಜೊತೆಗೆ ನಿರ್ಣಯಿತ ಪ್ರಕರಣಗಳ ಹಲವಾರು ಮಾಹಿತಿಗಳನ್ನು ಒಳಗೊಂಡಂತೆ ತಮ್ಮ ಅನುಭವದ ಅಮೃತವನ್ನ ಈ ವೇದಿಕೆಯಲ್ಲಿ ನಮ್ಮೆಲ್ಲರಿಗೂ ಉಣಬಡಿಸ್ತಿದ್ದಾರೆ. ಬಹುಶಃ ಗೌರವಾನ್ವಿತರಿಗೆ ಅವರಿಂದ ತಿಳ್ಕೊಳ್ಳುವಂತ ಸಾಕಷ್ಟಿದೆ. ಹಾಗಾಗಿ ನಾನು ಮಧ್ಯದಲ್ಲಿ ಇಂಟರಪ್ಟ್ ಮಾಡಿ ಗೌರವಾನ್ವಿತರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಅನ್ನ ಮಾಡ್ಕೊಂಡಿರುವಂತದ್ದು, ಇನ್ನೊಂದು ಉಪನ್ಯಾಸವನ್ನ ನಾವು ನೀಡ್ಲಿಕ್ಕೆ ತಯಾರಿದ್ದೇವೆ. ತಾವು ತಮ್ಮ ಅಮೂಲ್ಯವಾದ ಸಮಯವನ್ನ ಕೊಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇದೆ. ಇನ್ನೊಂದು ಉಪನ್ಯಾಸವನ್ನ ಮಾಡೋ ಮುಖೇನ ಇನ್ನಷ್ಟು ಮಾಹಿತಿಗಳು ನಮಗೆ ಸಿಗಲಿ ಅನ್ನುವಂತ ಕಾರಣಕ್ಕೋಸ್ಕರ ವಿನಂತಿಯನ್ನ ಮಾಡ್ಕೊಂಡಿದ್ದು. ಗೌರವಾನ್ವಿತರು ಇವತ್ತು ಏನ್ ನಮಗೆ ಉಪನ್ಯಾಸವನ್ನ ನೀಡಿದ್ದಾರೆ, ಆ ಉಪನ್ಯಾಸಕ್ಕೆ ಸೀಮಿತವಾಗಿ ಯಾರಿಗಾದ್ರೂ ಪ್ರಶ್ನೆಗಳಿದ್ದಲ್ಲಿ ತಾವು ಹ್ಯಾಂಡ್ ಅನ್ನ ರೈಸ್ ಮಾಡಿ. ಹಲವಾರು ಜನ ಮಾಡಿದ್ರಿ. ಮತ್ತೆ ಯಾರಿಗಾದ್ರೂ ಪ್ರಶ್ನೆಗಳಿದ್ದಲ್ಲಿ ತಾವು ತಮ್ಮ ಹ್ಯಾಂಡ್ ಅನ್ನ ರೈಸ್ ಮಾಡಿದ್ರೆ ಪ್ರಶ್ನೆಗಳನ್ನ ಕೇಳಕ್ಕೆ ಅವಕಾಶ ನೀಡಲಾಗ್ತದೆ. ಅವಕಾಶವನ್ನ ನೀಡಿದಾಗ ತಮ್ಮ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ ನಂತರ ತಮ್ಮ ಪರಿಚಯವನ್ನ ಮಾಡ್ಕೊಂಡು ತಾವು ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಬೇಕು ಅನ್ನುವಂತ ವಿನಂತಿಯನ್ನ ಮಾಡ್ತಾ, ಮೊದಲಿಗೆ ವಿಭಾ ಮೇಡಮ್ ಅವರು ಬಹುಶಃ ಯಾವ ಬಾರು ಅಂತ ಹೇಳಿ ತಮ್ಮ ಪರಿಚಯ ಮಾಡ್ಕೊಂಡು ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿ. ಮೇಡಮ್, ನಿಮ್ಗೆ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಕ್ಕೆ ಅವಕಾಶವನ್ನು ನೀಡಲಾಗಿದೆ. ಎಸ್ ಪ್ಲೀಸ್ ಮೇಡಮ್.
ನಮಸ್ಕಾರ ಸರ್, ನಾನ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಡಿಸ್ಟಿಕ್ ಇಂದ ಬಾರ್ ಕೌನ್ಸಿಲ್. ಓಕೆ ಸರ್, ತಮ್ಮ ಉಪನ್ಯಾಸ ಬಹಳ ಚೆನ್ನಾಗಿ ಬಂತು ಸರ್. ಆಕ್ಚುಲಿ ನೀವು ಬಹಳ ಡೀಟೇಲ್ ಆಗಿ ಸವಿಸ್ತಾರವಾಗಿ ಹೇಳಿದ್ರಿ. ಆಮೇಲೆ ನನ್ಗೆ ಅನ್ಸುತ್ತೆ ನೀವು ಹೀಗೆ ಇನ್ನೊಂದು ಸಿಟ್ಟಿಂಗ್ಸ್ ಗಳನ್ನ ನಮ್ಗೆ ಹೇಳಿದ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ಈಗ ನಮ್ಗೆ ಅದು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಡೀಪ್ ಆಗಿ ಹೌ ಇಟ್ ವರ್ಕ್ಸ್ ರಿಯಲಿ ಅಂತೇಳಿ ಅರ್ಥ ಆಗುತ್ತೆ. ಆಕ್ಚುಲಿ ಅದನ್ನ ನೀವು ಸವಿಸ್ತಾರಾಗಿ ಹೇಳಿದ್ರಿ. ರಿಯಲಿ ನೀವ್ ಹೇಳಿರೋ ರೀತಿ ನೋಡಿದ್ರೆ ವಿ ಆರ್ ಸೋ ಹ್ಯಾಪಿ. ಯಾಕಂದ್ರೆ ಕೆಲವೊಂದು ಪಾಯಿಂಟ್ಸ್ ಗಳು ನಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ ರೆಗ್ಯುಲರ್ ಆಗಿ ಹೌ ಇಟ್ ವರ್ಕ್ಸ್ ಇನ್ ದ ಕೋರ್ಟ್ ಅಂತೇಳಿ. ಸೊ ಆ ಪಾಯಿಂಟ್ಸ್ ಗಳನ್ನ ಯಾಕಂದ್ರೆ ಬುಕ್ ಅಲ್ಲಿ ಓದ್ತೀವಿ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಓದ್ತೀವಿ, ಪ್ಲೇಂಟ್ ಓದ್ತೀವಿ, ಬಟ್ ವೆನ್ ವಿ ಕಮ್ ಟು ದ ಪ್ರಾಕ್ಟೀಸ್ ಅದು ಅಲ್ಲಿ ಡಿಫ್ರೆಂಟ್ ಆಗಿರುತ್ತೆ. ನೀವು ಅದು ಪ್ರಾಕ್ಟೀಸ್ ಮೂಲಕ ನಮ್ಗೆ ಅದು ಸಂಸ್ಕಾರವಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ, ಅದಕ್ಕೆ ಇನ್ನೊಂದ್ ಸೆಟ್ಟಿಂಗ್ ನಿಮ್ದು ಕೊಡ್ಬೇಕಂತೇಳಿ. ಈಗ ಸಪೋಸ್ ನೀವು ರೆಡಿ ಮಾಡಿದಂತ ನೋಟ್ಸ್ ನಮ್ಗೆ ಬೇಕಂದ್ರೆ ನಾವ್ ಯಾವ ತರ ತಗೋಬಹುದು ಅಂತ ಅದನ್ನು ಕ್ವಶನ್ ಕೇಳ್ತಾ ಇದೀನಿ.
ಅದು ಸಾಮಾನ್ಯವಾಗಿ ನಾನು ಯಾವ್ದು ನೋಟ್ಸ್ ಮಾಡೋದಿಲ್ಲ,
ನೋಟ್ಸ್ ಪ್ರಿಪೇರ್ ಮಾಡಲ್ಲ ರೀ,
ಯಾವಾಗ್ಲೂ ನೋಟ್ಸ್ ಮಾಡೋದಿಲ್ಲ. ಓನ್ಲಿ ಡಿಸಿಷನ್ಸ್ ಇರುತ್ತೆ, ಅದನ್ನ ಹೇಳ್ತೀನಿ ನಾನು ಹಾಗೆ.
ತಾವು ಮಧ್ಯ ಒಂದ್ ಸ್ವಲ್ಪ ಸೈಟೇಷನ್ ಗಳನ್ನು ನಮ್ಗೆ ಕೊಟ್ರೆ
ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಗ್ಬೋದು.
ಸರ್ ತುಂಬಾ ನೀವು ರಿಯಲಿ ವಂಡರ್ಫುಲ್ ಆಗಿ ನಮ್ಗೆ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರಿ ಸರ್. ಎಲ್ಲರ ವತಿಯಿಂದಲೂ ನಾನು ಧನ್ಯವಾದ ಹೇಳ್ತೀನಿ ಸರ್. ನೀವು ಹಾರ್ಡ್ಲಿ ಎಲ್ಲ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರಿ. ಯಾವ್ದು ಒಂದು ಪಾಯಿಂಟ್ ನೀವು ಮನ್ಸಲ್ಲಿ ಇಟ್ಕೊಳ್ಳೋದೆ ಅಥವಾ ಹೈಡ್ ಮಾಡದೆ. ಹೆಚ್ಚಾಗಿ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲಿ ಏನಿರುತ್ತೆ, ಒಬ್ರು ಒಂದ್ ಹೇಳ್ತಾರೆ, ಇನ್ನೊಬ್ರು ಒಂದ್ ಹೇಳ್ತಾರೆ, ಕೆಲವೊಬ್ರು ಹೇಳಕ್ಕೆ ಹೋಗಲ್ಲ. There are many people, those do not explain outside people because ಅವ್ರ ಮುಂದೆ ಬರ್ಲಿ ಬೇರೆದವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಅವ್ರು ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಾವೆಲ್ಲಿ ಹಿಂದೆ ಉಳಿತೀವೋ, ನಾವು ಭಯದಿಂದ ಹೇಳಲ್ಲ. ಬಟ್ ನೀವು ಅಟ್ ಲೀಸ್ಟ್ ಅಟ್ ದಿಸ್ ಪಾಯಿಂಟ್ ಆಫ್ ವ್ಯೂ ನೀವು ಇಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ಓಪನ್ ಆಗಿ ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ತುಂಬಾ ಧನ್ಯವಾದ ಹೇಳ್ತೀನಿ ಸರ್ ನಿಮ್ಗೆ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಪ್ರಶ್ನೆ ಇದೆಯಾ ತಮ್ಗೆ?
ಏನಿಲ್ಲ ಸರ್, ಆಕ್ಚುಲಿ ಇಶ್ಯೂಸ್ ನಮ್ಗೆ ಅದೇ ಒಂದು ಪ್ರಶ್ನೆ. ನೋಟ್ಸ್ ಇಸ್ ಒನ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್. ಆ ನೋಟ್ಸ್ ಬಗ್ಗೆ ನಾನು ಹೇಳಿದೆ ನಿಮ್ಗೆ. ಗೌರವಾನ್ವಿತರು ಉಪನ್ಯಾಸದಲ್ಲಿ ಅದನ್ನ ನಿಮ್ಗೆ ಸೈಟೇಷನ್ ಬಗ್ಗೆ ಕೋಟ್ ಮಾಡ್ತಾರೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್ ವಿಜಯಕುಮಾರ್ ಭಾಗವಜ್ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ತಮ್ಮ ಪ್ರಶ್ನೆಗಳಿದ್ದಲ್ಲಿ ದಯವಿಟ್ಟು ಅದನ್ನ ಕೇಳಿ, ಪರಿಚಯ ಮಾಡ್ಕೊಂಡು ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಿ. ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಗೌರವಾನ್ವಿತರು ನಾವು ಥ್ಯಾಂಕ್ಸ್ ಅನ್ನ ಕೊನೆಯಲ್ಲಿ ಹೇಳ್ತೀವಿ. ನಿಮಗೂ ಕೊನೆಯಲ್ಲಿ ಅವಕಾಶ ಕೊಡ್ತೀವಿ. ದಯವಿಟ್ಟು ಪ್ರಶ್ನೆಗಳಿದ್ರೆ ಕೇಳಿ.
ಸರ್, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಲೆಕ್ಚರ್ ವಾಸ್ ವೆರಿ ಗುಡ್ ಸರ್. ಆಕ್ಚುಲಿ ನಾನು ಸಿಂಪಲ್ ಒಂದು ಕ್ವಶನ್ ಇದೆ ಸರ್. ಸ್ವಾಮಿ ಸರ್, ಕ್ಯಾನ್ ಯು ಹಿಯರ್ ಮಿ ಸರ್?
ಹೇಳಿ.
ನಿಮ್ಮ ಧ್ವನಿ ಸ್ಪಷ್ಟವಾಗಿಲ್ಲ, ಇಕೋ ಬರ್ತಾ ಇದೆ.
ನಾವು ಸರ್, ನಾವು ಇವಾಗ ಸರ್.
ಎಸ್, ಹೇಳಿ ಸರ್.
ಹಲೋ,
ಹೇಳಿ ಸರ್, ಪ್ರಶ್ನೆ ಕೇಳಿ.
ಸರ್, ಸೆಷನ್ ವಾಸ್ ವೆರಿ ಗುಡ್ ಆಕ್ಚುಲಿ. ನಂದು ಒಂದು ಕ್ವಶನ್ ಆಕ್ಚುಲಿ ಸರ್, ಪೇಪರ್ ಹೇಗೆ ಅಟೆಂಡ್ ಮಾಡಬೇಕು, ಬರೀಬೇಕಂತ ಒಂದು 2 ಲೈನ್ ಹೇಳಿದ್ರೆ ಸಾಕು ಸರ್, ಮತ್ತೇನಿಲ್ಲ.
ಏನ್ ಹೇಳಿ?
ಅಲ್ಲ ಸರ್, ಆನ್ಸರ್ ಪೇಪರ್ ಈಗ ಕ್ವಶನ್ಸ್ ಕೇಳ್ತಾರಲ್ಲ ಸರ್. ಆಕ್ಚುಲಿ ಸಿವಿಲ್ ಲಾ ಅಂತ ಇರುತ್ತೆ, ಒಂದು ಕ್ವಶನ್ ಪೇಪರ್ ಇರುತ್ತೆ, ಕ್ರಿಮಿನಲ್ ಲಾ ಅಂತ ಇರುತ್ತೆ. ಹೇಗೆ ನಾವು ಬರೀಬೇಕು ಅನ್ನೋದನ್ನ ಬ್ರೀಫ್ ಆಗಿ ಒಂದು 2 ಸೆಂಟೆನ್ಸ್ ಹೇಳಿದ್ರೆ ಸಾಕು ಸರ್, ಅಷ್ಟೇ. ಮತ್ತೆ ಇಲ್ಲ
ಹೇಗೆ ಬರೀಬೇಕು ಅನ್ನೋದನ್ನ ಹೇಳ್ಕೊಡ್ಬೇಕಾ?
ಹೌದೌದು, ಅದನ್ನ ಸ್ವಲ್ಪ, ಯಾಕಂದ್ರೆ ಈ ಸೆಷನ್ ವಾಸ್ ವೆರಿ ಗುಡ್. ನಿಮ್ ಸೆಷನ್ ಕೇಳ್ಬಿಟ್ರೆ CPC ಓದೋ ಆಗತ್ತೆ ಇಲ್ಲ. ನಂದು ಅದ್ರ ಬಗ್ಗೆ ಕ್ವಶನ್ ಇಲ್ಲ. ನನಗೆ ಬ್ರೀಫ್ ಹೇಗೆ ಬರೀಬೇಕು, ಬಿಕಾಸ್ ಐ ಆಮ್ ಥರ್ಡ್ ಟೈಮ್ ಐ ಆಮ್ ಅಟೆಂಡಿಂಗ್ ದಿ ಮೇನ್ ಎಕ್ಸಾಮ್ ಆಕ್ಚುಲಿ.
ಸರ್, ನೀವು ಅದನ್ನೇ ಯಾವಾಗ್ಲೂ ಮಾರ್ಕ್ಸ್ ನೋಡಿ ಫಸ್ಟ್. ಅದಕ್ಕೆ ಯಾವಾಗ್ಲೂ ಹೇಳ್ತಿರ್ತೀನಿ, ನೀವು ಕ್ವಶನ್ ನೋಡಿದಾಗ ಫಸ್ಟ್ ಮೊದಲು ನೋಟ್ಸ್ ಇರುತ್ತೆ, ಅದು ನೋಡಿ. ಆಮೇಲೆ ಕ್ವಶನ್ ಗೆ ಏನೇನ್ ಮಾರ್ಕ್ಸ್ ಇದೆ ನೋಡಿ, ಆ ಕ್ವಶನ್ ಮಾರ್ಕ್ಸ್ ನೋಡಿ ನಿಮ್ಗೆ ಉತ್ತರ ಬರೀಬೇಕಾಗುತ್ತೆ. ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ಅಂತ ಹೇಳಿ ಕ್ವಶನ್ ಗೆ ಕಡಿಮೆ ಮಾರ್ಕ್ಸ್ ಇದ್ರೆ, ಜಾಸ್ತಿ ಬರೆದ್ರೆ ನಿಮ್ಗೆ ಟೈಮ್ ವೇಸ್ಟ್ ಆಗುತ್ತೆ. ಅದನ್ನ ನೀವು ಗಮನದಲ್ಲಿ ಇಟ್ಕೋಬೇಕು ಯಾವಾಗ್ಲೂ. ಅದಕ್ಕೆ ಮಾರ್ಕ್ಸ್ ಎಷ್ಟು ಇಟ್ಟಿದಾರೋ, ಈ ಶಾರ್ಟ್ ನೋಟ್ಸ್ ಉದಾಹರಣೆಗೆ 2 ಮಾರ್ಕ್ಸ್ 3 ಮಾರ್ಕ್ಸ್ ಇಟ್ಟಿರ್ತಾರೆ. ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ನೀವು ಅದು ಗೊತ್ತಿದೆ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ 2 ರೂಲ್ 2 ಬಗ್ಗೆ ಪೂರ್ತಿ ಬರೆಯಕ್ ಹೋದ್ರೆ ನಿಮಗೆ ಬೇರೆ ಕ್ವಶನ್ ಗೆ ಆನ್ಸರ್ ಮಾಡಕ್ ಟೈಮ್ ಸಿಗಲ್ಲ. ನೋಡಿ, ಅದಕ್ಕೆ ಎಷ್ಟು ಬೇಕಾ ಸಂಕ್ಷಿಪ್ತವಾಗಿ 1-2 ಲೈನ್ ಅಲ್ಲಿ ಬರೆದ್ರೆ ಮುಗಿತು. 2-3 ಮಾರ್ಕ್ಸ್ ಇರುತ್ತೆ. ಜಾಸ್ತಿ ಮಾರ್ಕ್ಸ್ ಇದ್ದಾಗ ಆರ್ಡರ್ ಸೆಕ್ಷನ್ 11 ಕೇಳ್ತಾರೆ, ಒಂದು 10 ಮಾರ್ಕ್ಸ್ ಇಟ್ಟಿರ್ತಾರೆ, ಅವಾಗ ನೀವು ಡೀಟೇಲ್ ಬರೀಬೇಕಾಗುತ್ತೆ ಜುಡಿಕಾಟ ಬಗ್ಗೆ. ಆತರ ಜುಡಿಕಾಟ ಅಂದ್ರೆ ಏನು, ಅದಕ್ಕೆ ಉದಾಹರಣೆ ಏನು, ಫ್ಯಾಕ್ಟ್ಸ್ ಇನ್ ಇಶ್ಯೂ, ಡೈರೆಕ್ಟ್ಲಿ ಅಂಡ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಇಶ್ಯೂ, ಕೋಲಾಟ್ರಲ್ ಇನ್ ಇಶ್ಯೂ, ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಇನ್ ಇಶ್ಯೂ, ಆಕ್ಚುಲಿ ದ ಸೇಮ್ ಅಂಡ್ ಕನ್ಸ್ಟ್ರಕ್ಟಿವ್ಲಿ ದ ಸೇಮ್. ಅವನ್ನ ವಿವರಣೆ ಕೊಟ್ಟು ಅದಕ್ಕೆ ಕೆಲವು ಉದಾಹರಣೆ ಕೊಟ್ಟು ಬರೆದ್ರೆ ಅವಾಗ ಸರಿ ಆಗುತ್ತೆ. ಆ ಪ್ರಶ್ನೆ ಅದನ್ನ ನೋಡಿ ಅದ್ರ ಪ್ರಕಾರ ನೀವು ಉತ್ತರವನ್ನ ಬರಿಬೇಕು. ಜಾಸ್ತಿ ಇದ್ದಾಗ ನೀವು ಡೀಟೇಲ್ ಬರಿಬೇಕು, ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದ್ದಾಗ ಕಡಿಮೆ.
ದೇವೇಂದ್ರ ಕುಮಾರ್ ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ನಮಸ್ತೆ ಸರ್, ಭವ್ಯ ಅಂತ ಚಿತ್ರದುರ್ಗ ಬಾರಿಂದ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ವಂಡರ್ಫುಲ್ ಸೆಷನ್ ಸರ್. ನಂದು 2 ಕ್ವಶನ್ ಇದೆ ಸರ್. ಒಂದು ಪ್ರೊಫಾರ್ಮಾ ಡಿಪೆಂಡೆಂಟ್ ಬಗ್ಗೆ ಕೇಳಿದಾರೆ ಸರ್, ಅದ್ರ ಬಗ್ಗೆ ಒಂದು. ಅನದರ್ ಕ್ವಶನ್ ದೇ asked one question, briefly discuss on the following issues in facts and fact in issue. Fact in issue evidence ಅಲ್ಲಿ ಬರುತ್ತೆ, we can understand, but what about issues in fact ಅಂತ ಕೇಳಿದಾರೆ ಸರ್. ಅದು ಕ್ವಶನ್
ಅದೇ, that is issues of fact. ಆರ್ಡರ್ 14 ನಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲಮ್ಮ, material proposition act affirmed by one party and denied by another party, that is issue of fact. That is the issue in fact. ಆಮೇಲೆ ಪ್ರೋಫಾರ್ಮಾ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ, where there is no relief claimed against a particular defendant is known as pro forma defendant, a proper defendant. It's not a necessary party, a proper party.
ಏನಾದ್ರು ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ ಸರ್?
ಯಾವ್ದಕ್ಕೆ?
pro forma defendant.
pro forma is only against him. ಈಗ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ತಗೊಳ್ಳಿ ಉದಾಹರಣೆಗೆ, ಇದನ್ನ ಹೇಳ್ತಿರ್ತೀನಿ ಯಾವಾಗ್ಲೂ. 4 ಸಿಸ್ಟರ್ಸ್, 4 ಜನ ಬ್ರದರ್ಸ್, 8 ಜನ. ಒಬ್ರು ಪ್ಲೇಂಟಿಫ್ ಸಿಸ್ಟರ್ ಕೇಸ್ ಹಾಕ್ತಾರೆ, ಮೂವರನ್ನ ಡಿಫೆಂಡೆಂಟ್ ಮಾಡ್ತಾರೆ, 4 ಜನ ಬ್ರದರ್ಸ್ 7 ಜನ ಡಿಫೆಂಡೆಂಟ್ ಮಾಡ್ತಾರೆ. ಒಬ್ಬ ಡಿಫೆಂಡೆಂಟ್ ಬ್ರದರು has already taken his due share by executing a registered release. So she mentioned ಅವಾಗಲೇ ಭಾಗ ಆಗೋಗಿದೆ, ಆದ್ರಿಂದ ಎಲ್ಲರಿಗೂ ನಮಗೆ 7ನೇ ಭಾಗ ಬರಬೇಕು, 8ನೇ ಭಾಗ ಅಲ್ಲ. 1/8, 1/7 we are entitled. That brother who has already taken his due share is not entitled for any share. So he is a pro forma defendant. Against him no prayer is made, no relief is claimed. ಆತರ.
Okay.
Only example.
Okay. Thank you, sir.
Well.
Thank you, sir. Thank you very much.
Welcome.
ರಂಗಪ್ಪ ಎಸ್ ಡಿ ಅವರು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ರಂಗಪ್ಪ ಎಸ್ ಡಿ ಅವರೇ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಗುಡ್ ಈವ್ನಿಂಗ್ ಸರ್.
ಗುಡ್ ಈವ್ನಿಂಗ್
ಸರ್. ನನ್ನ ಕ್ವಶನ್ ಬಂದ್ಬಿಟ್ಟು, ನಾನ್ ರಂಗಪ್ಪ ದೊಡ್ಡದೇವಣ್ಣವ್ರು ಅಂತ ಸರ್, ಆನೆಮನೂರ್ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಸರ್.
ಹೇಳಿ ಸರ್, ಹೇಳಿ
ಸರ್. ಒನ್ ಕ್ವಶನ್ ಇಸ್ ಅಬೌಟ್ ದಿ ಪ್ರಾಪರ್ಟೀಸ್ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಸರ್, ಬಟ್ ಬಿಫೋರ್ ದಟ್ ದಿ compromise decree is also made out. Compromise decree is also made out, sir. When compromise decree is made out, that is considered as a self-proclaimed property. This is my question, sir.
ನಿಮ್ಗೆ ಕ್ಲಿಯರ್ ಆಗಿಲ್ಲ.
Whether it is a when after partition is made out as per compromise decree, that property is a self-proclaimed property or ancestral property, sir.
Oh. It becomes the property of the person to whom it is given.
It is self-proclaimed property, sir. That is also brothers and sisters also they are agreed.
Sorry, repeat ಮಾಡಿ.
Brothers and sisters also agreed it is a self-proclaimed property, sir. That property is also go to that person.
What is the problem ಏನೀಗ?
The problem is they are now they are appeal the question, sir.
They are now
appealing. It is an ancestral property.
Appeal ಮಾಡಿದ್ರೆ ಅದನ್ನ you can always appear and support your case. ಅವ್ರು ಹೇಳ್ಬೋದು, ಅವರೇ ಒಪ್ಪಂಬಿಟ್ಟ ಮೇಲೆ it is estoppel.
No sir, my question, no sir, third person is appealing, sir. He is not concerned to that property.
Third party, what right he has got?
Only as an the sharer of the property.
No, he cannot. He has to file a suit for partition.
Yes, sir.
There you can say take all your contention.
Yes, sir.
Because the partition is already made, and they have no right to bequeath the property or sell the property.
Yes, sir. Yes,
they
sir.
are stopped.
Yes, sir. Yes, sir. Thank you, sir. Thank you. Thank you.
ಸುಧಾ ಮೇಡಮ್ ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಸುಧಾ ಮೇಡಮ್, ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್ ಸುಧಾ ಮೇಡಮ್ ಅವರ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಕ್ಕೆ ನಿಮಗೆ ಅವಕಾಶವನ್ನ ನೀಡಲಾಗಿದೆ. ನಾವು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೋಬಹುದು. ಎಸ್
ಹಲೋ ಸರ್.
ಹೇಳಿ ಮೇಡಮ್.
ನಮಸ್ತೆ ಸರ್.
ನಮಸ್ತೆ ಅಮ್ಮ.
Sir, at what stage of the proceeding counterclaim can be filed, sir? ಯಾವ stage ಅಲ್ಲಿ file ಮಾಡಬೇಕು sir?
The Supreme Court has already taken a decision. ಅದ್ರಲ್ಲಿ ನಮ್ಮ ಜಸ್ಟಿಸ್ ಮೋಹನ್ ಶಾಂತಗೌಡರು was a judge. He has already held that before framing of issues at the before recording of evidence, counterclaim can be allowed. Not beyond that. Even though it is within time, after that, court cannot permit the parties defendant to seek for counterclaim. Issues ಆಗೋದಕ್ಕೆ ಮೊದಲು ಅಥವಾ ಎವಿಡೆನ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗೋದಕ್ಕೆ ಮೊದಲು. Order 8 rule, capital A, 6A.
Sir, one more question, sir.
ಹೇಳಿ
sir, ಈಗ 9 rule 7 ಅಲ್ಲಿ we are for once defendant non prosecution ಮೇಲೆ dismiss ಆದ್ಮೇಲೆ whether he has to compulsory file misapplication or ಅದೇ ಸೂಟ್ ಅಲ್ಲಿ ರಿಸ್ಟೋರ್ ಆಗ್ಬೋದಾ ಸರ್?
ಇನ್ನೊಂದ್ಸರಿ ರಿಪೀಟ್ ಮಾಡಿ.
ಈಗ suit has been dismissed for non prosecution on 9 rule 7 sir.
Order 9 rule 9.
Order 9 rule 7.
8.
ಸೊ ಅದೇ ಸೂಟ್ ಅಲ್ಲಿ ರಿಸ್ಟೋರ್ ಆಗ್ಬೋದಾ ಅಥವಾ ಕಂಪಲ್ಸರಿಲಿ?
ಅದೇ You have to file a
ನಿಮ್ಮ ಧ್ವನಿ ಮ್ಯೂಟ್ ಆಗಿದೆ ನೋಡಿ.
You have to file a miscellaneous application
Hello,
with
sir.
order 9 rule 9. You cannot file a fresh suit. It is a bar.
Same
Order 9 rule 9 bar ಇದೆ.
Order 9 rule 9 bar ಇದೆ sir.
Bar for filing a fresh suit. ಬೇರೆ ಹೊಸ ವ್ಯಾಜ್ಯವನ್ನು ಹಾಕಕ್ಕಾಗಲ್ಲ. ನೀವೇನಿದ್ರು
Okay,
ಅದೇ
sir.
ಕೋರ್ಟ್ ನಲ್ಲಿ ಮಿಸ್ನೆಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹಾಕ್ಬೇಕು ಆರ್ಡರ್ 9 ರೂಲ್ 9 ನಲ್ಲಿ. ಅದೇ ಡೇಂಜರ್ ಅದು. ಅದಕ್ಕೆ ನಾನು ಯಾವಾಗಲೂ ಸೆಕ್ಷನ್ 12 ಹೇಳ್ತಾ ಇರ್ತೀನಿ. ಸೆಕ್ಷನ್ 12 ಮೇಕ್ಸ್ ಇಟ್ ವೆರಿ ಕ್ಲಿಯರ್, wherever the court prevents a person from filing further suit, he shall not file a fresh further suit on the same cause of action. There are so many provisions, including this order 9 rule 9 section 11 of the code of civil procedure. ಇನ್ನೂ ಸುಮಾರು ಇದಾವೆ. ಅಲ್ಲೇ ಹಾಕ್ಬೇಕು ನೀವು ಆರ್ಡರ್ 9 ರೂಲ್ 9 ಸೇಮ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಹಾಕ್ಬೇಕು.
ಜೆ ಚಂದ್ರಶೇಖರ್ ಪಾಟೀಲ್ ಅವರು ಧ್ವನಿಯನ್ನು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಜೆ ಚಂದ್ರಶೇಖರ್ ಪಾಟೀಲ್ ಅವರು ಧ್ವನಿಯನ್ನು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಪರಿಚಯ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಚಂದ್ರಶೇಖರ್ ಪಾಟೀಲ್ ಅವರೇ, ನಿಮ್ಮ ಧ್ವನಿ ಪುನಃ ಮ್ಯೂಟ್ ಆಗಿದೆ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ
ಸರ್. ನಮಸ್ಕಾರ
ಸರ್.
ಚಂದ್ರಶೇಖರ್ ಪಾಟೀಲ್ ಅಡ್ವೊಕೇಟ್ ಸರ್, ರಾಯಚೂರು.
ಹಾ ಸರ್ ಹೇಳಿ
ಸರ್. ಏನಿಲ್ಲ, ನಂದೊಂದು ಕ್ವಶನ್ ಸರ್. ಈ ಮಾರ್ಟ್ಗೇಜ್ ರಿಡಂಪ್ಷನ್ ಆಫ್ ಮಾರ್ಟ್ಗೇಜ್ ಸೂಟ್ ಅಲ್ಲಿ ಸರ್,
ನಿಮ್ಮ ಧ್ವನಿ ಪುನಃ ಮ್ಯೂಟ್ ಆಯ್ತು. ನಿಮ್ಗೆ ತಾಂತ್ರಿಕ ತೊಂದರೆ ಇರ್ಬೋದು ಅನ್ಕೊಂತೀನಿ ನಾನು. ಎಸ್
ಹಲೋ ಸರ್, ನಮಸ್ಕಾರ ಸರ್.
ಹೇಳಿ ಪ್ರಶ್ನೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ
ಸರ್. ಈಗ ಒಂದು ಮಾರ್ಟ್ಗೇಜ್ ರಿಡಂಪ್ಷನ್ ಆಫ್ ಮಾರ್ಟ್ಗೇಜ್ ಸೂಟ್ ಅಲ್ಲಿ ಸರ್, ಅದು ನಾವು ಸೂಟ್ ಹಾಕಿದೀವಿ ಸರ್. ಈಗ ಮಾರ್ಟ್ಗೇಜ್ ಏನ್ ಮಾಡಿದಾನೆ ಸರ್, ಹೈಕೋರ್ಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತೇಳಿ ಅವನು ಮಾರ್ಟ್ಗೇಜರ್ಗೆ. ಹಲೋ ಸರ್,
ನಿಮ್ಮ ಧ್ವನಿ ಓಕೆ ಪುನಃ ಕಟ್ ಆಯ್ತು. ಸಾರಿ ಸರ್, ಸಾರಿ. ನೆಕ್ಸ್ಟ್ ಪ್ರಶ್ನಾರ್ಥಿಗಳು BM ದೇವಟಿಯರ್ ಗದಗದಿಂದ ಧ್ವನಿಯನ್ನು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸರ್ ನಮಸ್ತೆ ಸರ್.
ಹೇಳಿ
ಸರ್. ಈಗ ಒಂದು ಪ್ಲೇಂಟ್ ರೆಡಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಾವು ಈಗ ಸೆಕ್ಷನ್ ವೈಸ್ ಮತ್ತು ಆರ್ಡರ್ ವೈಸ್ ಬರಿಬೇಕಾಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಿ ಸರ್. ಅದನ್ನ ಸ್ವಲ್ಪ ಬ್ರೀಫ್ ಆಗಿ ಹೇಳಕ್ ಆಗುತ್ತಾ, ಅಥವಾ ಲೆಂಗ್ತ್ ಇದ್ರೆ ಬೇಡ ಸರ್, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಹೇಳಿರಂತ. ಹಾ ಸರ್, ಆರ್ಡರ್ ವೈಸ್ ಮತ್ತು ಸೆಕ್ಷನ್ ವೈಸ್ ಹೇಳ್ತಾರೆ.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಲೆಂತಿನ ಆಗಿದೆ ಅದು, ಟೈಮ್ ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಾಗ ಅವಕಾಶ ಕೊಟ್ಟಾಗ ಹೇಳ್ತೀನಿ.
ವಿಭಾ ಮೇಡಮ್ ಅವರು ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ವಿಭಾ ಮೇಡಮ್ ಅವರೇ, ನಿಮಗೆ ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಅವಕಾಶವನ್ನ ನೀಡಿದೆ. ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್. ನಂದು ಏನ್ ಕ್ವಶನ್ ಅಂದ್ರೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸಮ್ ಆಫ್ ದ ಟ್ರಿಕ್ಸ್ ವಿಲ್ ಬಿ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಹೇಳ್ತಾರೆ ಯೂಶುವಲಿ.
ಏನ್ ಹೇಳ್ತಾರೆ?
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಸೊ ಅದ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಯಾವ ತರ ಮಾಡ್ಬೇಕು, ಏನೇನ್ ಕಂಟೆಂಟ್ ನಾವು ಇಟ್ಕೋಬೇಕು, ಹೆಚ್ಚಾಗಿ ಯಾವ ತರ ಮಾಡ್ಬೇಕು ಅನ್ನೋದೊಂದು ನೀವೊಂದು ಕ್ಲಾಸ್ ತಗೋತೀರಾ ಅಂತ ಕ್ವಶನ್ ಅಷ್ಟೇ.
ಮೇಡಮ್ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ನಾನು ಆಗ್ಲೇನೆ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೆ. ಈಗ ಸರ್ ಇಶ್ಯೂಸ್ ಮಟ್ಟ ಬಂದಿದ್ದಾರೆ, ಇನ್ನು ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್ ಆಗಿಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಅವತ್ತಿನ ಉಪನ್ಯಾಸದಲ್ಲಿ ನೀವು ಈ ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಬಹುದು.
ಆರ್ಡರ್ 18 ನಲ್ಲಿ ಮಾಡೋಣ. ಆರ್ಡರ್ 18 ಡೀಲ್ ಮಾಡಿದಾಗ ವಿಲ್ ಡೂ ದಟ್.
ಓಕೆ ಸರ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಎನ್ ಮೂರ್ತಿ ಅವರು ದಯವಿಟ್ಟು ಇವತ್ತಿನ ಉಪನ್ಯಾಸಕ್ಕೆ ಅದರಲ್ಲಿ ಏನ್ ತಿಳಿದಿಲ್ಲ ಅಂತ ಕೇಳಿ ನೆಕ್ಸ್ಟ್ ಗೌರವಾನ್ವಿತರು ಮತ್ತೆ ನಮಗೆ ಅವಕಾಶವನ್ನ ಕೊಟ್ಟು ಉಪನ್ಯಾಸ ಮಾಡಿದಾಗ ಅದ್ರ ಬಗ್ಗೆ ಕೇಳಿರುತ್ತೆ. ಇವತ್ತಿನ ಉಪನ್ಯಾಸದಲ್ಲಿ ಏನಾದ್ರು ತಿಳಿದೇ ಇದ್ರೆ ಕೇಳಿ. ಎನ್ ಮೂರ್ತಿ ಅವರೇ ದಯವಿಟ್ಟು ಧ್ವನಿಯನ್ನು ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್
ಸರ್, ನಮಸ್ಕಾರ ಸರ್.
ನಮಸ್ಕಾರ
ಸರ್. ನಮ್ದೊಂದು ಕ್ವಶನ್ ಸರ್.
ಹೇಳಿ ಸರ್.
ಮೂರ್ತಿ ಅವರೇ, ಯಾವ ಬಾರ್ ಅಂತ ಹೇಳಿ
ಸರ್. ನಮ್ದು ಬೆಂಗಳೂರೇ ಸರ್.
ಕೇಳಿ.
ಎ ಅಂಡ್ ಬಿ ಅಣ್ಣ ತಮ್ಮದಿರು ಸರ್. ಬಿ ಇದು ಪ್ರಾಪರ್ಟಿ ಸರ್. ಅದು ಎ ಡಿಕ್ಲರೇಷನ್, ಎ ಬಿ ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಆಗ್ತಾರೆ. ಅಲ್ಲಿ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಬಿಗೆ ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟವ್ರೆ ಅಂತ ಪ್ರೇಯರ್ ಕೇಳ್ತಾನೆ. ಬಿ ಪ್ರಾಪರ್ಟಿ, ಅದು ಬಿ ಅವ್ರದ್ದು ಪ್ರಾಪರ್ಟಿ. ಎ ಅವ್ರಿಗೆ ನನಗೆ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಅವರು ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಇಬ್ರು ಪ್ಲೇಂಟಿಫೆ, ಎ ಅಂಡ್ ಬಿ ಇಬ್ರು ಪ್ಲೇಂಟಿಫೆ.
ಡಿಫೆಂಡೆಂಟ್ ಯಾರು?
ಡಿಫೆಂಡೆಂಟ್ ಥರ್ಡ್ ಪರ್ಸನ್ ಮಾಡಿ,
ಸರಿ,
ಇವ್ರಿಬ್ಬರನ್ನ ಪ್ಲೇಂಟಿಫ್ ಮಾಡಿ ಎ ಪ್ರಾಪರ್ಟಿ ಬಿಗೆ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ಕನ್ಸೆಂಟ್ ಮಾಡಿ ಅಂತ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಕೇಳಿದಾರೆ ಸರ್.
ಅವ್ರಿಬ್ಬರನ್ನ ಡಿಕ್ಲೇರ್ ಮಾಡ್ರಿ ಅಂತನಾ? ಎ ಅಂಡ್ ಬಿ ಅನ್ನ ಡಿಕ್ಲೇರ್ ಮಾಡ್ರಿ,
ಒಬ್ಬರನ್ನ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ.
ಸರಿ.
ಅದರಲ್ಲಿ ಆಲ್ರೆಡಿ ಒಂದು 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಇವಾಗ ಗೊತ್ತಾಗಿ ಬಿಗೆ ಇವಾಗ ಅಮೆಂಡ್ಮೆಂಟ್ಗೆ ಹಾಕೊಂಡ್ಬೋದಾ ಅಂತ ಕೇಳಿ ಸರ್.
ಏನ್
10 ವರ್ಷ ಸ್ಟೇಜ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸರ್.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದ್ರೆ ಅದು ಆರ್ಡರ್ 6 Rule 17 ಬರಲ್ವಲ್ಲ. ಆಫ್ಟರ್ ದಿ ಎವಿಡೆನ್ಸ್ ಇಸ್ ಕಮೆನ್ಸ್ಡ್, ಅದನ್ನ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಯಾಟಿಸ್ಫೈ ದಿ ಕೋರ್ಟ್. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಯುವರ್ ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಯು ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಸೀಕ್ ದಿಸ್. ಅದು ನಿಮ್ಗೆ ಯಾವಾಗ ಗೊತ್ತಾಯ್ತು ಏನು ಅದೆಲ್ಲ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ರೆ ಕೊಡ್ಬೋದು. ಅದನ್ನ ಮಾಡಿ ನೀವು ಅದು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿ ಆರ್ಡರ್ 6 Rule 17 ನಲ್ಲಿ ಕೇಳಿ.
ಇನ್ನೊಬ್ರು ಗ್ಯಾಲಾಕ್ಸಿ A12 ಅಂತ ಬಂದಿದ್ರಿ, ದಯವಿಟ್ಟು ನಿಮ್ಮ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಹಾಕೊಂಡಿರೋದೇ ಗ್ಯಾಲಾಕ್ಸಿ A12 ಅಂತೇಳಿ. ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಅವಕಾಶವನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ, ತಾವು ಧ್ವನಿಯನ್ನ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೋಬಹುದು ಸರ್. ಎಸ್, ಪರಿಚಯ ಹೇಳಿ ಮೇಡಮ್. ನಿಮ್ಮ ಹೆಸರು ಹಾಕೊಂಡ್ ಬರಬೇಕು. ನಮಸ್ಕಾರ ಮೇಡಮ್. ನೋಡಿ, ಇಲ್ಲಿ ಗ್ಯಾಲಾಕ್ಸಿ A12 ಅಂತ ಬರ್ತಾ ಇದೆ ನಿಮ್ಮ ಹೆಸರು. ದಯವಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಜಾಯ್ನ್ ಆಗುವಾಗ ಹೆಸರು ಹಾಕೊಳ್ಳಿ.
Yes, sir. Speaking, sir. Speaking, sir.
Please.
Yes, sir. Yes, sir.
You may ask question.
Myself, Advocate Muthulakshmi from Hassan Bar, sir.
Heli ma.
Sir, thank you for your valuable guidance, sir.
Okay, welcome.
Sir, one of the question has been asked in 2015 question paper of DJ exam, sir. Who is called as pocket defendant?
Pocket defendant.
Sir, pocket defendant yaru sir?
ಗೊತ್ತಾಯ್ತು. Pocket defendant. There is it is not in vogue in our country. It was in England. Pocket defendant ಅಂತ ಹೇಳಿ ನನಗೂ ಇಲ್ಲ. ಆಮೇಲೆ ಯಾರೋ ಇದೇ ತರ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರೆ ನಾನು ಹುಡುಕ್ದೆ ಏನಪ್ಪ ಇದು ಅಂತ ಹೇಳಿ. ಯಾವ ಪ್ಯಾಕೆಟ್, ಶರ್ಟ್ ಪ್ಯಾಕೆಟ್, ಪ್ಯಾಂಟ್ ಪ್ಯಾಕೆಟ್. ಆಮೇಲೆ ಕೇಮ್ ಟು ನೋ ದಟ್ it is in England, it is in vogue. Pocket defendant is one who has the sourceful person ಅಂತ ಹೇಳಿ. In the tortious cases ಅಲ್ಲಿ ಇಂಗ್ಲೆಂಡ್ ನಲ್ಲಿ they used to fixed liability on a person even though he is not directly liable to pay, only because he is a sourceful person ಅಂತ ಹೇಳಿ. ಈ tortious liability ನಲ್ಲಿ ಕೇಸ್ ಹಾಕಿದಾಗ ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು, 2-3 ಪ್ರತಿವಾದಿಗಳು ಇದ್ದಾಗ ಅವ್ನು ನಿಜವಾಗಿ ಯಾರು ಹೊಣೆಗಾರ ಆಗ್ತಾನೋ ಅವನ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ ಅಂದಾಗ ಅವನ ಜೊತೆಗೆ ಇನ್ಯಾರು ಇದ್ರೆ ಅವನನ್ನು ಹೊಣೆಗಾರ ಮಾಡೋರು. ಇಫ್ ಈಸ್ ಎ ಸೋರ್ಸ್ಫುಲ್ ಪರ್ಸನ್, ಅವನಿಗೆ ದುಡ್ಡಿದೆ, ಚೆನ್ನಾಗಿದೆ ಅಂತ ಹೇಳಿ. ಅವಾಗ ಈ ಪಾಕೆಟ್ ಡಿಫೆಂಡೆಂಟ್, ಡೀಪ್ ಪ್ಯಾಕೆಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ಕರಿತಾ ಇದ್ರು. ಡೀಪ್ ಪ್ಯಾಕೆಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂದ್ರೆ ಅವ್ನು ದುಡ್ಡು ಇಟ್ಕೊಳ್ತಾ ಇದ್ದನ್ನು ಹೊರಗೆ ತೆಗಿತಿರ್ಲಿಲ್ಲ. ಒಳಗಡೆ ದುಡ್ಡು ಇಟ್ರೆ ಕೆಲವು ಖರ್ಚು ಮಾಡಲ್ವಲ್ಲ, ಎಷ್ಟು ಜುಗ್ಗನ ನೀನು ಅಂತೀವಲ್ಲ, ಆ ತರ ಡೀಪ್ ಪ್ಯಾಕೆಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ಕೆಲವು ಅಂತಾರೆ. ಸೊ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಎ ಸೋರ್ಸ್ಫುಲ್ ಪರ್ಸನ್ ಈಸ್ ನೋನ್ ಆಸ್ ಪಾಕೆಟ್ ಡಿಫೆಂಡೆಂಟ್.
Sourceful person.
ಹೌದು, ಸೋರ್ಸ್ಫುಲ್ ಪರ್ಸನ್.
ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್. ಆತ್ಮೀಯ ಬಂಧುಗಳೇ, ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು KSBC ಲಾ ಅಕಾಡೆಮಿಯ ಇಂದಿನ 6ನೇ ದಿನದ ಈ ಉಪನ್ಯಾಸ ವೇದಿಕೆಯಲ್ಲಿ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶ ಹುದ್ದೆಯ ಮುಖ್ಯ ಪರೀಕ್ಷಾರ್ಥಿಗಳಿಗಾಗಿ ಈ ಒಂದು ಕಾನೂನು ತರಬೇತಿ ಕಾರ್ಯಾಗಾರವನ್ನ ಪ್ರಾರಂಭ ಮಾಡಿದರೆ, ಈ ಒಂದು ವೇದಿಕೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಮನವಿಯನ್ನ ಮನ್ನಿಸಿ ಈ ವೇದಿಕೆಗೆ ತಮ್ಮ ಅತ್ಯಮೂಲ್ಯವಾದ ಸಮಯವನ್ನ ನೀಡಿ ನಮ್ಮ ಹಿರಿಯ ವಕೀಲರಾಗಿರ್ತಕ್ಕಂಥ ಶ್ರೀ ಜಗದೀಶ್ ಮುಂಡ್ರಿಗಿ ಸರ್, ಬಹುಶಃ ಅವರ ಉಪನ್ಯಾಸ ಅಂತಂದ್ರೆ ಅದು ಸಾಕಷ್ಟು CPC ಒಂದು ಕಬ್ಬಿಣದ ಕಡಲೆ, ಅದನ್ನ ಅಷ್ಟು ಸರಳೀಕರಣವಾಗಿ ನಮ್ಮೆಲ್ಲರಿಗೂ ಅರ್ಥವಾಗುವ ರೀತಿಯಲ್ಲಿ ಗೌರವಾನ್ವಿತರು ಸಾಕಷ್ಟು ಉಪನ್ಯಾಸಗಳನ್ನ ಈಗಾಗಲೇ ನೀಡಿದ್ದಾರೆ. ಇವತ್ತು ಸಹಿತ ನಮ್ಗೆ ಅಷ್ಟೇ ಹುರುಪು ಹುಮ್ಮಸ್ಸಿನಿಂದ ತಮ್ಮ ಅನುಭವವನ್ನ ನಮ್ಮೆಲ್ಲರ ಜೊತೆಗೆ ಹಂಚಿಕೊಂಡಿದ್ದಾರೆ. ಅಂತ ಗೌರವಾನ್ವಿತರಿಗೆ ನಾನು ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು KSBC ಲಾ ಅಕಾಡೆಮಿಯ ಪರವಾಗಿ ಹಾಗೂ ಈ ವೇದಿಕೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿರ್ತಕ್ಕಂಥ ಎಲ್ಲಾ ಪರೀಕ್ಷಾರ್ಥಿಗಳ ಪರವಾಗಿ ತುಂಬ ಹೃದಯದ ಧನ್ಯವಾದಗಳನ್ನು ಸಲ್ಲಿಸ್ತೇನೆ.
ಮತ್ತು ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ, ಅಕಾಡೆಮಿಗೆ, ಮತ್ತೆಲ್ಲ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಅದೇ ರೀತಿ ಬಂಧುಗಳೇ, ಈ ವೇದಿಕೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿರ್ತಕ್ಕಂಥ ಎಲ್ಲಾ ಪರೀಕ್ಷಾರ್ಥಿಗಳಿಗೂ, ಗೌರವಾನ್ವಿತರಿಗೂ, ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲ ಪರಿಷತ್ತಿನ ಎಲ್ಲ ಸದಸ್ಯರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನು ತಿಳಿಸ್ತೇನೆ. ಹಾಗೇನೆ ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮವನ್ನ ಏನು KSBC ಲಾ ಅಕಾಡೆಮಿಯ ಯೂಟ್ಯೂಬ್ ಇದೆ, ಯೂಟ್ಯೂಬ್ ನಲ್ಲಿ ವೀಕ್ಷಣೆ ಮಾಡ್ತಿರ್ತಕ್ಕಂಥ ಎಲ್ಲಾ ಬಂಧುಗಳಿಗೂ ಸಹಿತ ಧನ್ಯವಾದಗಳನ್ನು ತಿಳಿಸ್ತಾ, ನಾಳೆ ದಿವಸ ಈ ವೇದಿಕೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾಗಿರ್ತಕ್ಕಂಥ ಸನ್ಮಾನ್ಯ ಶ್ರೀ ಶ್ರೀಶಾನಂದ್ ಸಾಹೇಬರು ನಾಳೆ ದಿವಸ CRPC ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಉಪನ್ಯಾಸವನ್ನ ನೀಡೋರಿದ್ದಾರೆ. ದಯವಿಟ್ಟು ನಾಳೆಯೂ ಸಹಿತ ಹೆಚ್ಚಿನ ಸಂಖ್ಯೆಯಲ್ಲಿ ತಾವೆಲ್ಲ ಭಾಗವಹಿಸಿ ಗೌರವಾನ್ವಿತ ಉಪನ್ಯಾಸದ ಉಪಯುಕ್ತತೆಯನ್ನ ಪಡೆದುಕೊಳ್ಳಲಿಕ್ಕೆ ಅಣಿಯಾಗಬೇಕು ಅನ್ನುವಂತ ವಿನಂತಿಯನ್ನ ಮಾಡ್ತಾ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮವನ್ನ ಇಲ್ಲಿಗೆ ಮುಕ್ತಾಯ ಮಾಡೋ ಸಮಯ. ಇಂದಿರಾ ಸುಹಾಸಿನಿಯವರು ಕೈ ಎತ್ತಿದ್ದೀರಿ. ಬಹುಶಃ ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಗೌರವಾನ್ವಿತರ ಉಪನ್ಯಾಸ ಇದ್ದಾಗ ನಿಮಗೆ ಅವಕಾಶವನ್ನು ನೀಡಲಾಗ್ತದೆ. ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನು ತಿಳಿಸ್ತಾ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮವನ್ನು ಮುಕ್ತಾಯ ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಎಲ್ರಿಗೂ ಶುಭವಾಗಲಿ. ಶುಭರಾತ್ರಿ.